Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, let's go on the record. Cause numbers 23 DCCR 1502 and 24 DCCR 1320. So in cause number, hold on a second. Let's see what I got. Well, there's actually, those are both, sir, are you Ronnie Green? Okay, and so Mr. Green's here with Mr. Galmore and Mr. Coleman is here. Mr. Green was previously in court in those two cases, entered pleas of not true in motions to revoke his probations in each of those cases. He's on probation for possession of a prohibited weapon and possession of marijuana, both third-degree felony offenses. It looks like I think they're both 5-year deferred probations. And there is a new allegation of a new offense in cause number 25 DCCR 0735, which is money laundering. Mr. Green was in court before and entered pleas of not true to counts 1 and 2 in that motion, in each of those motions, which alleged number 1, the new money laundering case. And in addition, count 2 was the offense of having a wrong, fictitious, or altered or obstructed license plate as well. And we're here for a hearing. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
The state has, Judge.
Judge, if I could have just 1 minute, I thought this was the PSI from prior when he pled on the case, so I have not reviewed it. I didn't
Okay.
realize this was an updated one, but I'll just look at it real quick.
Okay.
Oh, no, Judge, this is not an updated PSI. This is.
No, there is, you're looking at the regular, there is an updated one.
Okay, well,
It should have been emailed to you.
Here, I've got it.
Mhm. Ma'am, that's what was attached to yours. He just has the old one. Mine's attached to the old one, but it doesn't look like he's got the. This,
yes, Judge, we seen the updated PSI.
okay. So do we send that to him or that? I do. Yeah, okay. Okay, so are there any additions or corrections to that updated PSI?
Not from the defense.
Not from the state, Judge.
In addition to that, Mr. Coleman has filed a state's motion to modify the defendant's condition of probation. Have you seen that, Mr. Galmore?
Your Honor, the one that was filed in what's it, November of 2025?
September.
Yeah.
Yeah, I've seen it.
So what Mr. Coleman has filed and is requesting, have you guys had an opportunity to visit about what his recommendation is?
We have, Judge, but I believe his recommendation is going to be based on successfully proving true his violations, and we pled not true to those violations. I believe if the court were to find those violations were not true, then his motion for the majority of it anyways would be moot.
Okay, and does the state have witness with regard to those violations?
Yes, Your Honor.
All right, you may call your first witness.
At this time, the state calls Stacy Bradley, Judge.
Good morning. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may have a seat. And Ms. Chopper Bradley is the probation officer, correct?
Yes, Your Honor.
Okay, and you have officers as well on the offense?
Yes,
Okay,
sir.
gotcha.
Judge, before we get going, I'd ask that the court take judicial notice, the court's file, including probation, the conditions of probation.
Yes, I will.
Would you please state your full name for the court reporter?
Stacy Chapel Bradley.
And how are you employed, Ms. Bradley?
I'm a Jefferson County Community Supervision Officer with the high risk and medium risk caseload.
And as part of your duties is with probation, have you had an opportunity to supervise a Ronnie Green III?
Yes, I have.
Do you see Ronnie Green III in the courtroom here today?
I do, sir.
Would you please point to him and identify him by the article of clothing that he's wearing?
He's the middle in the black hoodie.
I'd ask the record reflect that the witness identified the defendant.
The record will so reflect.
Now, have you always supervised this defendant or did you take over his case?
I took over his caseload, sir,
When was that?
in July of 25.
And he's, just to kind of put this stuff on the record, I know the court's taking judicial notice of it, but he's on 2 concurrent felony probations, right? 3rd-degree felony prohibited weapon
Yes, sir.
and a 3rd-degree possession of marijuana, correct?
Yes, sir.
And he's got a 5-year deferred on both of those, correct?
Yes, sir.
In addition to those, he has a misdemeanor probation he's on for possession of a dangerous drug. That's a 1-year deferred, correct?
Yes, sir.
And you're familiar with the process by which all defendants are explained the conditions of their probation, correct?
Yes, sir.
Is there any reason to believe that the conditions of probation were not
Sorry.
were not explained to this
Thank you.
defendant?
There's no reason, sir.
Is there any reason to believe that this defendant did or does not understand the conditions of his probation?
I believe he does.
Okay. And as a condition of his probation, he is prohibited from committing any laws against this state, any other state, or the United States, correct?
Yes, sir.
And if he were to have violated chapter 34.02 of the Texas Penal Code as it relates to money laundering, would that be a violation of the law?
Yes, sir.
A violation of his conditions of probation as well?
Yes.
And if he were to have violated section 504.945 of the Texas Transportation Code as it applies to having a wrong or fictitious license plate, would that be a violation of his conditions of probation?
Yes, sir.
And in addition to those law violations, has there been any other infractions committed by this defendant during his probation?
Yes, sir. There were,
Judge, I believe we're here on 2 allegations, allegation 1 and 2. Any other infractions would be proper for sentencing, but I don't think it'd be relevant at this time.
I do agree, Judge, and I can recall, Ms. Bradley, if you want, or the instance of expediency, if the court would just consider that for purposes of punishment, that portion of the testimony, if we get to the punishment.
Any objection to me go ahead and hearing that for that purpose only if we get there?
If the court's going to hear it for limited purposes of sentencing only, no objection to that.
Okay. You can go ahead then.
Thank
I'll do it. I'll take judicial notice that it is only for sentencing if we get to that point.
Thank you, Judge.
Go ahead.
We were talking about any other issues or infractions during probation.
yes, sir.
What were they?
They were testing positive for marijuana and for THC rather and cocaine.
Testing positive for THC on more than one occasion?
Yes, sir.
And also, are you aware of the defendant's arrest in Chambers County back in January of 2024 for possession of a controlled substance?
Yes, sir.
And you understand that the state has filed a motion asking that this court, rather than revoke this defendant, if the court is so inclined to modify the defendant's conditions of probation so that he serve confinement in a safe P treatment facility. You understand, correct?
I understand.
And in fact, is that what you initially recommended in your updated PSI?
Initially, sir.
Okay, all right, I'll pass it with the judge.
Thank you, Mr. Coleman. Mr. Gilmore?
I have no questions at this time, Judge, subject to recall.
All right, thank you. Maybe you can step
Thank
down, but stay just in case we need you.
Yes, ma'am.
Do we know the result or of the Chambers County 2024 possession case?
I do not.
Not yet, ma'am. I called and they have not returned my phone call.
Okay, all right, thank you. You may call your next witness.
Yes, Judge, State Police Officer Rosendo Lopez.
The transportation code, what section is that again?
504.945, Judge.
Thank you. Good morning, sir. Would you please raise your right hand? Sorry.
Good morning.
Do you swear or affirm the testimony you're giving in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may proceed.
Thank you, Your Honor. Would you please state your full name for the court report?
Lucindo Lopez.
And Officer Lopez, how are you employed, sir?
There you
Lucindo Lopez.
How are you employed, sir?
Currently employed with Beaumont Police Department.
Certified peace officer?
Yes, sir.
Prior to working for Beaumont Police Department, were you with Port Arthur Police Department?
That's correct. Yes, sir.
More specifically, were you working for PAPD back on March the 3rd of 2025?
Yes, sir.
At around 12:16 PM, were you working alone or with a partner?
With a partner.
That partner being Christian Villasana?
Yes, sir.
And were you at or near the 3600 block of Gulfway Drive in Port Arthur, Texas at that particular time?
Yes, sir.
And that's located within Jefferson County, Texas, correct?
That's correct. Yes, sir.
Please tell the judge what, if anything, caught your attention.
What caught my attention on the vehicle license plate, the check through MDT computer revealed and confirmed that it expired back in 2023. And that's the reason why we pulled the vehicle over to further investigate the license plate.
And that vehicle being a silver 2008 Volkswagen,
Yes, sir.
being operated by someone that you ultimately identified as Ronnie Green III.
Yes, sir.
Do you see Ronnie Green III in the courtroom here today?
Yes, sir.
Could you please point to him and identify him by an article of clothing that he is wearing?
Black hoodie.
So you get this table.
Disabled black hoodie.
Your Honor, I asked the court, did the record reflect the witness identified the defendant, judge?
The record will so reflect.
Now, after you effected this traffic stop, was the defendant, the driver of that vehicle, the only or sole occupant of that vehicle?
Yes, sir.
Upon closer inspection of that plate, what did you observe?
There's deficiencies in the plate, like the way it was laminated, the barcode didn't scan anything. The license plate actually showed that it expired in April of 2025.
And what we're talking about, just to be clear for the court, is a purported paper plate that was a Texas buyer's license plate, correct?
That's correct.
And it didn't scan back to any vehicle, correct?
I'm sorry.
And it was in fact, it showed to be expired, correct?
That's correct.
And you were familiar with this defendant prior to this traffic stop, correct?
That's correct.
In fact, back in February of 2024, you arrested him for a felony possession of a controlled substance, correct?
That's correct.
That controlled substance being marijuana and promethazine, correct?
That's correct. Yes, sir.
For which, at least one of those cases, he was placed on felony probation.
That's correct.
That knowledge of the prior arrest and probation, in conjunction with what you observed in the vehicle, what did it lead you to believe?
That the money that was earned in plain view was proceeds from illegal narcotics activity.
Explain to the judge exactly what we're talking about as far as the money or the cash that you observed in the vehicle. What did you see?
The cash was bundled up in what I refer to as double increments, which I learned through my experience in training narcotics as a narcotics detective with Beaumont in the past, as well as all the schools that I've gone through. It's where drug dealers bundle up money and separate increments so they can separate their money from actual money that is earned from the proceeds or profit.
In fact, this was readily observable in plain view when you first approached the vehicle, right?
Yes.
I'm kind of moving through this to expedite this proceeding, but back in that February 2024 arrest, were there indicators of drug trafficking?
Yes, sir.
Including the surveillance on a residence that that was occupied by this defendant, where vehicles were coming and going frequently, correct?
Yes, sir. We actually received a tip reference to a narcotics location, narcotics being distributed in that residence.
And when he was arrested for the marijuana and arrested for the promethazine, was there also a digital scale as well?
Yes, sir.
So again, with all of this background knowledge and the cash that was found or that you observed in bundled in what you refer to as doper increments, did you form an opinion?
Yes, sir.
What was that opinion?
That the money that was in the vehicle was, proceeds from illegal activities or narcotics distribution.
How much did that money total?
Can I reflect on those?
Please.
You may.
Objection, Judge. We're gonna move to suppress the search, the results of the search. He has not actually testified as to the exact findings inside yet, but I do believe that if he's gonna give the denomination of the amount of money that was found, that would be admitting the evidence, and we're gonna move to suppress that.
Okay, is there a motion filed for a suppression? You're just doing it now.
Moving to suppress right now. I believe that puts the burden on me to prove whether there was warrant or not.
Well, we know there wasn't a warrant, so we need to know whether or not there was.
If the state concedes
Probable
there was no
cause.
warrant, then I believe the state now has the burden to prove that they had probable cause to search the car.
Judge, if I can ask just a couple more questions, I'm gonna address that with a
Okay.
couple questions.
Let me, so first, Mr. Coleman, there was not a warrant for this stop or arrest, correct?
Correct.
Okay, then, it'll go ahead as far as lay some, more foundation with regard to the probable cause for that stop
Yes.
and search, please.
Officer Lopez, now, you asked for consent to search the vehicle, and that consent was refused, correct?
That's correct.
Now, at this point, you had an arrestable offense, that arrestable offense being the fictitious license plate.
That's correct.
Under no circumstances, or regardless of how this turned out, was this defendant going to be released?
That's correct.
He was going to be arrested for that fictitious license plate
Right.
offense, correct?
That's regardless, I already knew that he was gonna go to jail for the license plate.
Now, and because he was going to be arrested, and because you were not releasing that vehicle to anyone, that vehicle was going to be towed, correct?
That's correct.
In fact, it was towed by American Towing, correct?
That's correct.
And EAPD has a policy by which any vehicle that is towed would be inventoried prior to it being towed.
That's correct.
And so just to recap, regardless of any consent or lack thereof, or the validity of a subsequent K-9 alert or lack thereof, this defendant was going to be arrested, the vehicle was going to be inventoried, and that cash that was inside that vehicle was going to be seized for further investigation as to whether or not it was proceeds of illegal activity.
That's correct.
I have more questions, Judge, but I don't know if that.
Do you have any questions of the witness with regard to the suppression issue? And then you can do that, and then I'll make that determination, and Mr. Coleman can continue.
I do have a couple questions.
Go ahead.
Real quick, you had stated that the vehicle's inspection sticker, the registration sticker is expired 2023.
Can I look at my notes? The exact date?
Yes, sir.
Was, what was the date you said? I'm sorry.
Will you tell me what was the date that it was last registered, or what date did it become expired?
That expired in March of 2023, and that was through the check through the MDT computer.
Do you know who owned it in 2023 when it became expired?
I didn't document it in my report, but I know it was on the MDT.
Okay, do you know whether it was Ronnie Green or not?
It was not Ronnie Green. As a matter of fact, we had a conversation about it belonged to a Hispanic guy out of Houston, Texas.
Okay, so and you were able to verify that it belonged to a Hispanic guy in Houston, Texas?
We weren't able to verify because he no longer had that person's point of contact, cell phone number, and he advised he bought it from Facebook Marketplace, and he was unable to get hold of the owner.
Okay, but you had access to records internally within the police department, right?
Right, but I don't think we keep records of phone numbers for subjects in Houston. I don't think it's gonna document in RMS.
Sure, but I guess my question is, did you verify the name of the owner?
Verify the name of the owner?
I mean, what did your system say who owned it in 2023?
Without that information from me, I would have to go back and run the plate again.
But it wasn't Ronnie Green.
It wasn't Ronnie Green.
Was it the person's name that he gave you?
I'm not sure. I would have to watch the video again.
What about in 2025 when this stop was made? Did you look up to see who owned the vehicle at the time that you made the stop?
Yes, the MDT computer. Yes.
Okay. Did the computer say that Ronnie Green owned the vehicle?
No,
Okay. Who did it say owned the vehicle?
You're asking a question that I can't remember. I'd have to go back and pull up the MDT computer or the video to watch it,
We may be able to answer that after we watch the video, right?
possibly.
Okay. But to be clear, in 2025, when you stopped Mr. Green in that vehicle, he was not the registered owner.
That's correct.
At any time since then, have you looked up to see at any time has the registration of that vehicle changed?
Yes, so he had the title in the glove box that had 3 owners, but none of them were ever switched over to each owner.
Okay, let me ask you that. And then, so he had in the vehicle, he had a title,
That's correct.
and it was to that vehicle.
That's correct.
Did you ever look to see if any of the names of owners on that title matched the name that the vehicle was owned by in your system?
I'd have to go back and watch the video. But none of the names on that title had green on it.
I understand that. But did any of the names match who you believe to be the true owner according to your internal system that you're allowed to use?
So we'd have to go back and watch the video.
That tag that you believe was fictitious, or that was fictitious, you don't know who put that tag on the vehicle, do you?
That's correct.
You don't know how long it's been on the vehicle.
That's correct.
The reason why you arrested Mr. Green for that violation at some point was because he was the driver of the vehicle. Is that correct? Not because you had knowledge that he had placed the tag on the vehicle.
He was operating a vehicle that had a fictitious license plate on it.
Okay. Do you know what the correct mens rea is for that offense?
Judge, I would object. That's a legal question outside of the
Sustain.
expertise of this witness.
Did you ask Mr. Green if he put that tag on the vehicle?
Let me reflect my notes. Let me see where we're at. Yeah, according to my report, I didn't put it in there.
Sorry.
We'd have to watch the video. I'm not sure. I didn't put that in my report.
So you don't know if you even asked Mr. Green if he put the tag on there?
I'm not even sure. I'd have to go back.
Did Mr. Green ever tell you anything about the tag?
The only thing that he said that he purchased the vehicle from Facebook Marketplace. He was unable to get a hold of the previous owner to change the title. And then the title showed that it had 3 different owners from the city of Houston. He also advised that he actually advised he purchased the vehicle from a Hispanic guy in a different city, but didn't know how to get in contact with him.
Since the arrest of this case, have you done any investigation as to who owns the vehicle or if the vehicle ownership has changed?
No, sir.
Not at all.
No, sir.
Isn't it common that when you buy a used vehicle, that it will have a paper plate,
We have a temporary tag.
temporary tag?
Right, those changed.
Isn't that basically what was on the vehicle, some kind of temporary tag?
I mean, there was just like, it looked like it was photocopied, laminated, and the barcode didn't scan to nothing. They're supposed to be able to come back to what the vehicle is registered to the owner.
But it was a paper plate, right?
It was laminated. It was a Xerox copy paper plate that was laminated.
Was it metal?
No,
It wasn't consistent with a permanent plate.
right, that's correct.
It was consistent with like a temporary plate that you would receive when you buy a new or used vehicle.
That's correct.
And Mr. Green told you he had just bought it used, correct?
About 3 months prior to this stop.
Why did you ask for consent to search the vehicle?
So I knew I was gonna arrest him regardless for that offense. Matter of fact, he had contacted his mother. I think he requested to release the vehicle to his mother. I said no, because policy, since we had to tow the vehicle, especially if we're gonna conduct an inventory in the vehicle, suspect vehicle. And the reason why I did that, if you watch video on scene, I contacted the district attorney's office and spoke to two DA, defense attorney or prosecutors to let them know what I have. And I was instructed to get further additional evidence on top of what I already have in reference to the money, so we can actually investigate money laundering at that point. So regardless, I'm still gonna go in that vehicle, still take that money and conduct a further investigation for the money laundering, which I later filed that case.
So my question was though, is at the time, whenever you saw the money, you got him out of the vehicle, why did you ask for him consent to search his car?
To get additional evidence for the money laundering, because for a future case that I was gonna investigate, that's the case.
So let me make sure I understand right, okay? So you got him out of the vehicle. You decided you were gonna arrest him right then. But before you acted on that, you called the district attorney's office.
Well, I explained to him, I asked for a consent to search, I explained to him, he asked me why.
Hold on, I wanna make sure we get in the right order of events here.
Yeah, we're gonna go back, I'm laying out to you exactly where I got him out of the vehicle for safety reasons. So I'm not, at this point, don't know if there's any weapons in the vehicle, or anything can harm us, and we want to further investigate the real life plate lights. We got him out of the vehicle. He asked me, I asked for consent, he asked me what for. I said, hey, I have reasonable suspicion that there's possibly narcotics in this vehicle. And I laid out to him, I know you're on felony probation, I know Hannah before, we have a previous encounter with each other. I know you left another narcotics location, and this is the reason why I'm contacting K9.
Okay, pause that thought. You just gave several reasons why you believe you had reasonable suspicion at that point in time, correct?
That's correct,
Okay, reasonable suspicion gives you the right to detain someone, right?
that's correct,
And you then, because of that reasonable suspicion you had, decided that you wanted to search his car.
for
Right,
additional evidence towards the money laundering case.
right. And so you then asked him for that permission,
That's
right?
right,
And then that permission would have allowed you then to search the car with his consent, right?
that's correct.
Okay, but he didn't give you that consent.
I didn't get my consent.
And so then you decided to go call the district attorney's office?
I want to figure out how we can further proceed to seize the money as a vehicle, because I knew it's from proceeds from illegal activities.
So at that time, you believed you had reasonable suspicion,
That's correct.
but you wanted additional advice on how to handle that reasonable suspicion or what to do with it?
Additional evidence or additional evidence to go about the procedure of actually seizing that money,
Okay, so who'd you call?
the district attorney's office.
Okay, well, you called the elected district attorney or you? called
So
the
I
department's office?
talked to Raymond Shear, the intake attorney, laid it out to him. He referred me to Kathleen and civil forfeiture, and I spoke to her on the phone. And all that's on video
Okay, the goal is to get your hands on the money.
for an additional charge of money laundering.
And so based on those conversations, was it discussed that you should just go ahead and open a door and just go ahead and get what you want out? Was that the advice you were given?
No, so I already told them that he was gonna go to jail regardless, gonna do inventory. But they suggested or strongly advised that, hey, to get additional evidence, see if the money would alert other the odor of narcotics would, the canine handler would alert on the vehicle for narcotics odor.
Okay, so let me make sure I understand right. You believe you have reasonable suspicion.
Mhm.
District attorney's office says, don't just search the car, get a drug dog out.
Correct.
And he has not consented to a search yet.
That's correct.
Okay, so drug dog comes out,
That's
right?
correct.
You believe you had reasonable suspicion to call that dog out?
That's correct.
You know you need that, right? You need reasonable suspicion to call it.
And I just explained what all the reasonable suspicion I had for narcotics in that vehicle.
Okay. And based on that reasonable suspicion, you decide to employ a drug dog to determine if there's probable cause to search the car.
To alert on the money, to see if it has a narcotics odor.
Well, but you ran the dog on the car, not the money.
Well, if the money's been around narcotics, it's gonna have to be narcotics.
First of all, you didn't handle the dog, right?
No, I don't handle them.
How's that dog been trained?
That officer's here and they can testify to how that dog's trained.
Do you know where that dog got certification?
I don't.
Okay, so you don't really know if it's a drug dog, right?
Well, I do. It's if they're certified to work for the city of Port Arthur for narcotics odor, I'm sure they are certified.
But you're assuming that based on the fact that a handler shows up with the dog, right?
Right. But you can ask, she's here, you can ask her.
Okay, perfect. And we will.
All right.
So the drug dog comes out and goes around the vehicle, right?
That's correct.
And then you're waiting on the handler to tell you whether the dog hit or not so that you can then search the car. Isn't that the way it works?
That's correct.
Okay, and so you're standing there and you're not participating in the drug dog searching part, right?
That's correct.
You're waiting on the handler to do their job.
To notify me that they alerted to narcotics odor response in the vehicle.
Okay, and when you receive that, that's when you then search the vehicle.
That's correct.
Okay, which is basically the way it's always done, right?
That's correct.
Okay. In your statement, you, in your report on page 9, can you go to page 9? On page 9, on the second paragraph, I'm gonna read that sentence to you and just, I wanna make sure that that's accurate. It says, shortly after K-9 Officer Williams arrived on scene and conducted a free air sniff on the suspect's vehicle, right, the vehicle. And then almost immediately, Officer Williams' K-9 partner alerted to the driver's side door on the suspect's vehicle, right? So the dog hit on the vehicle, not the money.
That's correct.
Right, and then Officer Williams advised her K-9 alerted, which provided us with probable cause search.
That's correct.
Okay, and then once in the vehicle, then marijuana was smelled.
Right. That's correct.
That's the proper chain of events,
Right.
right?
That's correct.
You have reasonable suspicion, so you call the drug dog.
That's correct.
Talk to the DA's office, they said call the drug dog.
That's correct.
Drug dog came out, hit, gave you probable cause,
Correct.
then you search the vehicle.
That's correct.
I'll pass the witness.
So any other questions, Mr. Coleman, with regard to the probable cause to search and the suppression issue before, I think I need to rule on that before we go any further into any other testimony.
Not with regard to the probable cause and the search, Judge.
So, Mr. Gallimore, do you think it's necessary for me to hear from the witness with regard to, well, I guess maybe I could answer that myself. My thought is based on the evidence, even prior to the dog being called or getting there, that the officer, and I understand you used the word reasonable suspicion and he said yes, but it appears as though there was probable cause, in my opinion, earlier than the calling of the drug dog. And I think he testified to numerous reasons that would back that up. Number one, the arrestable offense that he intended to arrest the defendant for, which would obviously lead to the ability to inventory the car. The fact that he saw in plain view the money that was packaged or separated in a way that through his experience is something that is indicative of drug dealing, and that it was in doper increments, in his words. In addition, the knowledge that this officer had of the defendant himself personally from the prior offense that he's on probation for, and in that offense, which is a drug offense, that there was also indications of drug dealing at a house that they were surveilling, as well as a scale in addition to the drugs that would indicate drug dealing and not just personal use. And he also, well, okay, I think that's it with regard to the probable cause for the search. And so at this time, I'm going to,
Judge, may I argue?
yeah, sure.
As it relates to whether there was probable cause at the time, the court stated that that he agreed with the word that I used. Number one, he did point out that in his report, it wasn't until, well, it was at the time that the K-9 handler alerted to him that the K-9 hit that he believed he had probable cause. That's what he put in his report. But it was is also his word in his report that he believed the description given as far as the previous offense and the doper money that he saw Oh, it was when Green asked the officer why he was gonna search the vehicle, is the officer, and I don't know if this was actually said specifically, but the officer stated, and it's gonna be on the video, that they had reasonable suspicion that narcotics were in the vehicle. So it seems to me that the testimony today has, and that was something else that's gonna be developed when we got past this point, but was that, the version is being given in a way to say, hey, we were gonna find it anyway. But when you look at the officer's perspective at the time, he believed he had reasonable suspicion. Those were his words that he used in his report. He also called the district attorney's office for advice on what to do. And their advice was not to search the vehicle, not that he had already had probable cause, but that he needed to have a drug dog. And then his words that were when the drug dog hit, he then had probable cause to search the vehicle. So the police and the district attorney's office at the time did not believe there was sufficient evidence to determine there's probable cause to search the vehicle at that time. And I tend to agree with them, to be honest with you, and that's the reason why we were having this hearing.
Mr. Coleman.
Judge, I think I agree with the court's line of reasoning and thought process as you laid it out before. I have nothing to add, Judge.
Well, I mean, is there any issue? I guess we can have Officer Lopez step down, get the other officer on. I can hear further evidence with regard to the canine. I don't think in my opinion, I don't believe it's 100% indicative of my, where I'm headed potentially, but it might give me at least more information. So let's do that. If you don't mind, sir, if you'll step down. Just stay handy. We'll get you right back in, and then let's get the next witness.
Think about Tiffany Williams, Judge.
Good morning, ma'am. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Have a seat, please. You may proceed.
Thank you, Your Honor. Would you please? Sorry, I'm trying to get this in my pocket. All right. Please state your full name for the court reporter.
Tiffany Williams.
And Officer Williams, how are you employed?
I'm employed with Arthur PD as a patrol officer.
Okay, and I'm going to ask you to speak up a little louder. The court hears everything you have to say. Are you a certified peace officer?
Yes,
In addition to being a certified peace officer, are you a certified K-9 handler?
yes,
Were you certified as a K-9 handler back on March the 3rd of 2025?
yes,
And were you working that day with your K-9 named Athena?
yes,
Is Athena certified as a K-9? Help me with the terminology. Certified.
she's certified through NNDDA, which is a nationally recognized certification for narcotics.
And was she so certified back on March the 3rd of 2025?
Yes,
And were the two of you called out to the 3600 block of Gulfway in Port Arthur, Texas, in Jefferson County that day?
yes,
And once you arrived, Officer Lopez, the assignment, they were on the scene with a silver Volkswagen that they conducted a traffic stop on, correct?
yes,
And they had a suspect who was identified as the driver who was standing outside of that vehicle. Did you see him in the courtroom today?
yes, he's wearing a black hoodie.
And do you know that his name that he was ultimately identified as?
Ronnie Green, sorry. Yeah, Ronnie Green.
Very good. I asked Your Honor, the record reflect the witnesses identified the defendant.
The record will so reflect.
And the process for running Athena on a vehicle or doing a free air sniff, very briefly, could you explain that for the court?
Normally the pattern I use is once I get her out, I let her take a break in a grassy area. If there's one close by, I bring her to the front driver corner of the vehicle. I give her a sit command, and once she sits, I give her a check command. We work normally in a counterclockwise pattern around the vehicle. And we conduct 2 passes if necessary. In this case, she didn't need the 2 passes, but that's typically the pattern that we go with.
And is there any reason you followed that process in this instance, correct?
Yes, we started that process.
You started that
Yes,
process. And at some point, did Athena alert on that silver Volkswagen?
yes,
And in the process or in the process of alerting on that silver vehicle. Well, tell the court what you recognize in the way of an alert. How do you determine if Athena alerts on a vehicle?
It's a change of breathing and a change of body posture.
And you observed that with Athena in this case, right?
Yes.
What kind of substance or substances is or was Athena trained to alert on?
It's marijuana and THC products, methamphetamines, crack, cocaine, heroin, including black tar and powder heroin.
And have you run Athena on a vehicle or vehicles on a few or on many occasions?
Many.
And have you found Athena to be reliable?
Yes.
In fact, have you found contraband in instances where she has alerted on few or on many occasions?
On many.
And in this instance, she alerted on that silver Volkswagen, correct?
Yes.
Now, let's be clear about something for the court. When she alerted, the driver's side window was down, correct?
Correct.
And it would appear that Athena, when she alerted, stuck her nose inside of that driver's side window at some point, correct?
Yes. What she showed, she started showing the signs, and then she went up trying to get closer to the source.
And you understand that and you and I have had this conversation. You understand that there is an argument, at least, that by sticking her nose into that vehicle, the argument could be made that that was an improper intrusion into that vehicle and could arguably invalidate the search, correct?
Yes.
Okay. But nevertheless, she did alert, correct?
Correct.
And once back at the PD.
Let me make sure, I just want to make sure, did she show signs before she had her nose in the vehicle or after?
Yes, ma'am. So she did both. Whenever you can tell by the way her body is, she'll stiffen her tail and curl it. And she showed the change of breathing, went to the driver side and then went up after. And then she stiffened her body while she was postured on the car.
And once back at the PD, what, if anything, was done or conducted?
I followed Officer Lopez and Officer Villasana to the station after the vehicle was picked up, and they set out 5 bags. One contained the money that was inside the vehicle, and the other 4 were blank. I did not know which one the money was in. They just had them out ready for me to go when I got there. And I again ran Athena on those money bags, and she showed a response to one of the bags, which I later learned contained the money.
You were equipped with a body-worn camera that day?
Yes.
That body-worn camera was properly operating as far as you know?
Yes.
You as the operator properly, certainly capable of properly operating it?
Yes.
This interaction, the dog alert on that silver Volkswagen was captured on your body-worn camera?
Yes.
May I approach the witness, Judge?
You may.
And I am going to show you what I am marking as State's Exhibit number 1. And I'm going to ask you first to identify this device for the record. What is this that I'm marking? What kind of a device is this?
It's a flash drive.
And the flash drive, you recognize it how?
Yes, I reviewed it with, and it has my initials and today's date on there.
And is this the body-worn camera that you just testified about containing the interaction with the vehicle that
Yes.
Athena alerted on?
Yes.
True and fair, accurate copy with no alterations or deletions as far as you know?
Correct.
Back, when was the last time you watched it?
A little while ago, just
Before testifying?
just before testifying.
State office states, 1, been previously provided to defense counsel in discovery. No objection.
States one's and admitted.
Commissioner Post.
Yes, sir.
Yeah, right? Hey, it's kind of, oh, I find it. No. Here. Right, seats. Check. Back, check. Cute. Check. Check. Hey, you're good. Hey, you're good. Girl, here. Hey, come back.
Just for the record, that was about in 11 seconds to 2 minutes and 20 seconds. For the record that states published. That's all I wish to publish it.
Leave it up there though.
Okay.
Does the other officer's body cam,
Street, the front dash camera, it shows a better view.
okay,
It captures.
I'm gonna wanna see that.
No, I'd have to find his body cam. I mean, his dash cam. I've got his body camera ready and queued up, but I'd have to find his dash cam.
Does the body cam show it?
I think it does.
If he's-
Yeah.
Yeah, I think the problem
It
is, I
does.
think the front dash shows the entire thing without moving around and everything. Like body cam, the problem is always it's constantly moving away from the
But if
action.
he's sitting, let's get him back so I can take a look at that. And then if we need to get more, we can come back either later this afternoon or continue the hearing to the appropriate time when we can get that. So with regard to
That's it. I have.
this
that's all-
part of it,
That's all I have for a judge.
okay, Mr. Galmore?
Now, I'm gonna ask as many questions as I can, and I may have to follow up with an additional question or two once we've seen the other videos, if necessary.
Okay,
Um. I'm sorry, what was your name again?
Tiffany Williams.
Officer Williams.
Yes, sir.
Where was this dog certified? You said NDAA?
NNDDA, we go through, one of their guys in Baytown. He has no, I can't remember where the address is, but the certifier has a building they use in Baytown.
Okay. Do you know where the dog was actually trained though? Like
They're-
originally?
Through Jefferson County.
Like they took the dog as a puppy and taught it how to be a drug dog?
I got her as a puppy and we did all the training here with a certified trainer,
Okay, who was the certified trainer?
Bill Crane.
Who was that?
He's a Jefferson County deputy.
And do y'all have like a book you use to train these dogs?
He does all his training stuff that he went through to a school with, and I think I went through a basic school with him, if I remember right, and then I train almost weekly with him as well.
Okay, let me ask you this. Do you have a book on how to train a canine, drug dog canine?
No,
No. So you relied on the training from Mr. Green.
Crane.
Crane,
Crane.
yes,
Bill Crane.
yeah, Bill Crane.
We're on here on Mr. Green's case. I heard that.
It's okay.
Okay, so Bill Crane trained the dog. You don't know exactly how Bill Crane trained the dog.
I was there with him for everything.
Okay.
So, yes.
Did you ever see Bill Crane refer to a book on how to train the dog?
Not during our trainings, but I know that he has before, just previous knowledge with him.
Then if you were around in the very beginning when this dog was trained, a dog is trained to hit, right?
They're trained for a response to odor.
Okay. That's what the industry calls a hit, right?
We refer to it as a response to odor. Well, you can have a final response to odor, or you have just response to odor.
Sure. But every dog, when they're trained to give a final response, right?
Correct.
That's kind of how the reward system is based, right?
Not necessarily.
Well, but to be fair, in order to know that the dog did the job correctly, you have to know that the dog is giving you the response.
Which would be the change of breathing and change of body posture.
Right. But each dog is trained to give a final response.
Yes, they're all trained different. Yes.
Okay. Changing breathing pattern is not a final response, right?
Not necessarily. I mean, you have everything that leads up to it. If you don't have that stuff, then you're not going to get to necessarily the final. In a case like this, we're on a major highway with a lot of vehicles moving around. We don't always wait for that final. Once we have enough for response to odor, which is what she showed in the video, then we'll move on from there.
What's the final response for this dog?
Change of breathing, or her final response
Yes.
is she normally sits.
Sit.
Yes,
Okay. So this dog is trained to sit when it smells drugs.
that's her final response that she shows.
That's what she's trained to do.
That's what she's trained to do for her final. Yeah.
Okay. And so whenever you are in not out on the field, but you're doing like your certification, right? Do you have to tell the judge beforehand what their final response is? Passive, aggressive, something like that?
I don't think it's a requirement. I think we normally do, but we're all normally familiar with each other as well.
Are you familiar with the narcotic detection standards by the National Narcotic Detector Dog Association?
Yes,
Okay, because that's the association your dog was certified by, right?
correct.
So when you're doing the certification testing or retesting, aren't you responsible for notifying the judge the type of alert that they can expect?
I don't remember if we tell them directly or not. Like I said, we're familiar with each other. I don't remember when we go in, we go, hey, mine's passive, I don't remember ever telling him that.
So you've never told the judge that my dog's trained to sit?
I can't recall.
Okay, but your dog is trained to sit.
That's what I've trained her, yes.
Okay, and whenever you've been in these certifications, has your dog sat when it found the drugs?
She has, but there's also times she has not, because all we have to do is inform the judge that our dog's in odor and they tell us yes or no.
So you keep saying this change of breathing pattern and body posture is to you is notice that the dog is hitting on something.
Correct, they're showing their response to the odor that they're smelling.
Where in any of your training does it say that you're allowed to rely on something other than the final response?
Multiple case laws in all our training.
Case laws, is that what you said?
Yeah,
Case laws?
don't ask me which ones. I can't, I'm not gonna be able to be specific right offhand.
Is that how you
That's
trained
what-
your dog, was using case law?
We all have to be familiar with it, so we're aware we can and cannot do.
You think, so Bill Crane, he would actually be the person who could testify as to how the dog was trained, right?
Yes,
And exactly what the response the dog should give.
yes, he would be able to answer all of those questions.
Okay. And whether in a particular situation, the dog actually hit or did not hit.
Yes, he would be able to explain it. I mean, he's gonna explain it the same way I am, that just change your breathing, change your body posture, but he will have all the technical terms for you.
So what's the standard breathing pattern for your dog when it's not alerting?
So whenever you see a difference, she'll close her mouth and she'll start sniffing really hard. That's what we normally look for. Same thing when they're tracking. You watch them picking their head up, putting their head down, the way they're breathing. So with her, normally she's gonna close her mouth. She's gonna open and she's gonna start sniffing a little bit harder, and she's gonna try to get to that source.
So what you're saying is that she thinks she smells something, so she sniffs harder and tries to then go towards where she thinks she's smelling something. That tells you that that's a hit.
There's more to it, but that's part of it. Yes.
Okay. But you don't have a book on how this dog was taught. No book at all.
I don't own one. No, I've had them passed on to me from other handlers. We've reviewed stuff, but I don't have one with me.
Have you ever seen in any of the records that you looked at that how this dog was? Well, first of all, have you ever looked at any documents at all on how this dog was trained?
I have all the documents. Yes.
Okay, you provided all those documents to him, right?
Mhm.
Where do you have those documents with you?
No.
Okay, do you have them electronically?
Yes, at the police department though.
Is there anywhere in there that says how that dog was trained to hit?
It should be in the beginning. We should go over some.
What was the name of that
basics.
document?
It's all in there. They're all training records.
You don't know the name of the document that says how the dog was hit?
No, because when I log everything, I normally do it training, date, and who I'm with.
Whenever we're on a break next, do you think maybe you could see if you could find any document at all that discusses how your dog is supposed to hit whenever it smells drugs?
I'm not gonna have it with me.
Well, but I mean, you can look electronically. Can you look electronically?
That's gonna be at the police department.
Okay, so you're really not sure. You think there's a document. You think you gave it to him.
There's all my training records. Now, if it specifically says she sits, or if it just says a final response, I know with the stuff with this stuff that she shows a response to odor. That's gonna be the difference. That's what you're gonna look for.
My question though is there anything in your records that says this dog was trained to sit when it smells drugs?
I would have to go back and look if it's specifically stated in it's sitting or if it's a final response.
What's to stop you from saying, hey, I taught this dog and, I could just tell you, you just acted different. So that's a hit.
Well, everything on everything we go by and everything we watch is on video.
Like a
So I can't just say, oh, well, they did this, and I have to have the proof there to back it.
Can we pull that up real quick? Or I can do it.
Just don't click.
Hey, I'm gonna walk right here, come with the most. That's fine. Yeah. Here. Hey. Yeah, ready?
It's kind of hard to hit pause in the right spot, but. A minute ago, you said that one of the things your dog does. That at least tells you
Yeah.
that the dog likes them.
Pause it while you're talking.
Sorry. One of the things earlier you testified to was not only was there a change of body, there a change of pattern, but a body posture.
Mhm.
And you said curl tail.
Yeah, so it's not just her normal playful tail. So like when you get further into it, I'll be able to point it out to you.
But you said curl tail.
Yeah, it's the way she stiffens her tail when she's doing it. It's hard to explain to you,
But is it curl like it curls up?
Her tail is normally curled up, but it's
different
more
type of
stiff.
curl,
Yeah.
Well, just out of curiosity, if we look at the video right here,
Yeah.
it's hard to stop it on time, but you can see right there, the dog's tail is curling up right there.
But it's not as stiff as it will be whenever she's showing that response.
It's more of a playful.
Yeah,
curl.
she's okay. Let's go. We're ready to go.
Hey, 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 see, it's fine. Oh, I can find it.
Okay, now right there, the dog was lower and pulling you right there, right?
Yes,
And looked more aggressive and a stiffer body posture right there, right?
she's just going to where we're going, ready to work.
She's ready to work, she's pulling.
Yep.
Okay. But you don't consider that a change of body posture?
It's a change, but it's not the change to a narcotic odor.
Because a minute ago, she had her tail curled, but you said that was a playful.
Mhm.
And now she's serious and ready to go to work, but that's also not the body posture change.
It's not a response to odor, correct?
Here. Here. Right.
Now, right there, her tail's straight up and curled, right?
Mm-hmm.
That's not the curled tail response you were talking about earlier, though?
No.
You're talking about different curled tail
Yes.
response. Okay.
Seats. Seats. Seats.
Okay, now you just told her to sit, right?
Yes.
Okay, now, a minute ago, you said sit is the actual hit that you would normally be looking for, right?
It's not when I tell her to do it. So like I explained earlier, our normal routine when we go to search a vehicle is I bring her to the front driver corner, I sit, get her focused, and then we start.
Okay, so you have her sit to start,
Mhm.
and then the end game is for her to sit again. That'd be a perfect.
If she's
response.
going to if she's gonna go into a final response, yes.
I mean, that's what she's trying to do, right?
Yes.
And so that would be a perfect ending to the whole thing, if she sits again.
Yes.
Okay.
Check.
And from the time she sits down to the time she gets back up and she's starting her search, her tail is still pointing straight up and kind of curled, right?
Yeah.
Check. Back. Back. Check. Check. Cute.
And within really just like 2 seconds of her getting up and you're telling her to check, she's already standing in the car. She's already standing up against the car, right?
Yes.
And her tail is still pointing up, just like it was the whole
Yeah.
time.
But when it's not paused, you'll see that it's more stiff instead of wagging back and forth.
Okay, let's back it up.
Yeah, and that's one of the things that you look for, the difference of it. It's not here play, let's wag, we're excited. This is business, this is work.
I know it's kind of hard to tell because this is your body camera, but whenever you see the dog's tail curling and stiffening, will you let me know?
Mhm.
And if we have to do this on another video later, we can.
Seats. Seats. Check. Check. Back. Back. Check. Check.
So right here, you're gonna notice she goes stiff. Her
Oh,
tail's
yeah,
not
right, yeah,
wagging.
saw it.
Yeah, her tail's not wagging anymore. She's stiff. She's, hey, basically, when we train, we'll learn how
Hold
to.
on, y'all can't talk while it's playing.
Okay, now I'm gonna give you my observation and then I'm gonna play it and then you just tell me if you agree or not agree, okay?
Okay.
Might be the easiest way to do this. I'm gonna play it and it appears that when she jumps up, sticks her head in, her tail is curled, it is wagging. But within, I would say 3 seconds, her tail then stiffens up. And then you just let me know if that's the way you observe it. That way we'll know if we're talking about the same thing or not.
Check. Check. Back. Back. Check. 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 Check.
Do you agree with that?
Yes, that's all the signs I'm looking for with her response to her.
So I want to make sure I understand. So she jumps up to the window. Her tail is curled but wagging, but it stops wagging within a couple of seconds.
Yes, you're, so same thing, you see it when she moves. They use their tail for, as their balance too. So just like it's connected to everything, when she moves, it moves again. But that's part of what I'm looking for. See, she's stiffened, she's looking at me, she's like, hey. And I always show this is what I say, hey, mom, it's right here. That's what I think whenever I see that. But it's not only her tail. So other than the tail, it's her body as well. You'll see her whole body tenses up. Her
Okay,
ears
so let me
perk up.
just, let me stop you. I mean, that's instantaneous. I do not see that there was even time prior to Athena jumping on the car for there to have been an alert. It was immediately in the car and then the alert happens. So I think that's enough with regard to, even if, and I'm not gonna, we don't need to get into certification, I don't think at this point, because I think now that we can go back to the rest of the evidence and whether or not there was probable cause, but with regard to that, I believe that based on what I'm seeing, I don't see that there could have been, unless I'm missing something, that there was an alert before.
It's
She was
so,
up.
yeah, the alert is, it's, that's why we try not to use that word, alert or hit, like a lot of us. It's a response. So when she, and I don't know if you'll be able to see it on the other one, if I remember right, that when I turn around and bring her back, when she's walking along the car, she does this, and we call it a headshot. That's their, oh crap, it was right there. They smelt something for a second, so we go back, do the sweep.
I'll have to
So,
see the other video.
Yeah, I don't know if it shows it in that or not, and that's just what I'm remembering.
And I'm not,
So-
and I'm not saying you, that I disbelieve what you're
Oh,
remembering.
right.
What the breathing and the tail, I mean, there was no time elapsed when I can see that the dog was at the window and just there for even a second before.
Yeah, everything kind of
jumped.
happens at once. She's,
Yeah. Okay, so I guess we need to figure out then, it's 12:15. We can handle this a couple ways. Obviously, Mr. Coleman, if you think that the body camera is the one that would have the more steady, solid shot that I would need to see, we can do a couple of things. I don't know time-wise today, or if we need to do this tomorrow. Y'all tell me schedules and then we can just, carry the hearing open.
Couple things, Judge. The body camera for Officer Lopez is going to essentially show what you're looking at here.
Then let's see
Uh,
that.
Okay, and then another thing is, I've got, in addition to Officer Lopez, I've got Special Agent David Clark here as well. So with that being said, there's some logistical things that make, for me at least, my preference would be to, if we can get it done today, get it done today.
Yeah, for sure. Same here. So, and if we needed, if anybody needs a break for,
I am set number 2 or 3 next door, but at this point, I don't expect it to go, so.
so then let's let's do another switch out. If you, ma'am, would mind, just stepping outside the courtroom again, and if we need you, we'll get you back in. And then let's get Officer Lopez back in and let's get that body camera.
We do this by stipulation. You're gonna make me go through the whole.
But second, by him asking this is the best video.
Yeah, I've got it.
You can come on up, sir.
It's part of all the. Say dash cam on it too, right? I think it's dash cam on it. Your Honor, I don't know, I'd offer state's exhibit number 2 by stipulation of the parties, Judge. It's, I could purport, represent to the court that it's the body worn camera of Officer Lou. Okay.
Okay, any objection?
I don't object, Judge. I believe it's got the body worn camera and the dash camera from his police car, and I don't object to the admission of those 2 videos.
Okay, that'd be great. It's admitted then.
Thank you, Judge.
For purposes of the suppression hearing.
Okay,
Fair enough.
so if I don't suppress it, I have to ignore that I saw it and watch it again?
Yes.
Okay. Bless you.
It does have both the dash cam and body worn cam.
Why don't we start with the dash cam?
Yes, ma'am.
Since it sounds like that might be the better stable view.
Purposes of the record, we're about 26 minutes and 59 seconds into the video.
Play it back again real quick, please. That's good.
Judge, I've got the body worn camera. I can go straight to that portion of the body worn camera if you like, Judge.
Sure, I'll take one more look at what you've got.
And around anybody has the odor on your body, because then. Yeah, I want to send one.
It's obviously not gonna be his camera.
I think you're right. No, I think you're right. It's not, it's just what you will see, of course, her Officer Williams walk back by.
Yeah,
And there was another.
okay. And I don't know, Mr. Coleman, we brought Officer Lopez back in. If you want to have Officer Williams come in and testify with regard to what we just saw. You know, I think we brought him in to lay the foundation,
Yep.
but it's her watching that with regard to that testimony. I don't know that I need any more explanation.
I don't know that there's much more the state can offer, Judge. I would just argue that the officer had the ability to arrest the defendant, the ability to inventory that vehicle. And had he chose to do so, inevitably, that cash would have been found. And based on the circumstances surrounding his prior interaction with this defendant and the prior drug arrest, he was going to further that investigation eventually into the source of that cash, Judge. That's really all.
Okay, and so with regard to the dog itself, I did not see what the Officer Williams explained as far as the dog's signal for not the final alert, but just the alert to a smell before the dog jumped up onto the car. And so all of those for that, I'm not going to take into consideration the dog and the alert that the dog had. So then I would just need argument from Mr. Galmore to follow up Mr. Coleman's argument with regard to whether or not there was probable cause
Judge, if I may, I'll have a few more questions for this officer.
on that note.
If you're not, if you pass,
Well, I did have
if you want to go, yeah, go ahead.
just a few more, but with regard to the suppression issue.
So with regard to the suppression, go ahead, whoever wants to go.
Couple things just to clarify and then a couple of follow-up questions. I think you heard me saying a minute ago something you might have said, but I want to make sure that we're on the same page with it. Back on page 9 of your report, you have that handy?
Yes, sir.
We have not seen it on the video. I'm assuming the video will corroborate this, but you said in your report that Green asked you why you wanted to search his vehicle, right?
That's correct.
And then you told him it's because you had reasonable suspicion that narcotics were in his vehicle.
That's correct.
Those are your words, right?
Yes, sir.
No one put those words in your mouth.
No, sir.
You chose the word reasonable suspicion.
And the reason why I chose those words is because I had reasonable suspicion to notify him that there's narcotics in that vehicle. And that is what starts the process to get K9 to be en route.
Okay, perfect. Now, you then, I believe we did say this on the record, but just to be clear, you then also put in your report on page 9 that after Officer Williams advised you that her canine alerted, that provided you with probable cause to search the vehicle.
That's correct. And once in the vehicle, then I smelled the odor of marijuana, additional probable cause.
And that's important because had you smelled the marijuana before you entered the vehicle, then that might have provided probable cause to search
That's
without the canine,
That's correct.
right? And even though a window was down, you never smelled the marijuana.
And I smelled it from outside the vehicle. That's what.
Now, you testified earlier about the prosecutor. I'm sorry about that you were going to arrest Mr. Green no matter what.
For the misdemeanor, yes.
It's your testimony that when you were getting out of the vehicle, that you were going to arrest him at some point, no matter what.
That's correct.
And so you, at this point, he's someone who's about to go to jail, right?
That's correct.
Okay. And so when you got him out of the car, did you tell him that he was going to be arrested?
No, not.
Did
I don't
you,
believe so.
did you tell him that he was under arrest?
They just told me he was detained and to have a seat on the ground so we can further conduct our investigation.
So you told him he was being detained.
I don't know if that's my exact words, but if we watch the video, that's fine. We can do it.
You certainly didn't tell him he was under arrest, though.
No, come on, you keep that from him until the last second.
Because you were trying to get probable cause to search the vehicle.
That's correct.
And so
Additional evidence.
did you handcuff him?
Not immediately, no, sir.
Okay. Did you put him in your cruiser and lock him in there?
Not immediately, no, sir. Had him come out and sit down on the sidewalk.
Okay, so he's basically about to be arrested, but for a long time, you don't handcuff him, you don't put him in your car, you let him walk all around the area, right?
That's correct.
But he's secretly being arrested though.
So I knew if I placed my handcuffs, then I would have to read his Miranda warning right there on the street to further ask him questions about the license plate and the money in the vehicle.
So you didn't arrest him because you wanted to trick him into talking.
I just wanted to get more information about him, violating his rights. If I would have put him in handcuffs, then he would, I would have to read his Miranda warning and then he can shut down right then and there.
So your concern was is if we told him he's being arrested and then he was aware of his rights, that he might exercise his rights.
That's a fair way to say yes.
Okay. Now, when you called the DA's office at the scene, was it their idea to trick him by not arresting
Don't
him?
object to the characterization about being tricked.
Well, that's what he just
I've
kind of
rolled
said. Was it their idea?
No,
Okay, so it was your idea.
no, it wasn't, there was no tricking whatsoever. I knew what I could do, what I couldn't do without violating his rights.
When did you formulate the idea that you were going to not arrest him in order to get him to talk to you more?
Not arrest him.
Yeah, I mean, when you got him out of the car, you didn't arrest him.
Oh, when I asked him to get out of the car, I already knew at that point that he was gonna go to jail.
Okay, so you had made up in your mind at the time you're getting him out that he was going to be arrested, but you were not going to arrest him right then.
That's correct.
And that was for the purpose of so that you could talk to him and get more information.
Further investigate both offenses.
So it wasn't the DA's office that told you to go that route.
That's correct.
So did they tell you to change your route at all?
No, they just gave me advice on how to properly go about investigating the money seizure portion of it to get additional evidence so the dog can alert to odors in that vehicle, which later on, if you continue reading the report, the dog alerted again back at the station during the 5-bag test that went straight to his money in a bag. And the additional evidence of reading his Miranda warning at the jail, him not admitting or not being very forthcoming with us in the interview at the jail. And he couldn't explain where he got the money from. He hadn't had a job since 2023.
We'll get to that in a minute.
All right.
As far as the topic of you had already decided to arrest him, okay? It's that discussion that we've been having today. And so that because of that, you were gonna find him was in the car anyways, right?
Inevitably, yes,
That's kind of what you said a minute ago, right?
that's correct.
Okay. When was the last time that you discussed that topic, just that topic, with the prosecutor?
The first time or the last time?
The last time.
Before we came here, we sat down and went over the questions he was gonna ask me.
Okay. When was the first time that that discussion occurred? That you were gonna arrest him anyway, so you were gonna find it anyway?
This last week, I think it was.
Okay, so the first time that ever came up in this whole investigation for you was last week.
Your Honor, that's a complete mischaracterization. The first conversation we had was last week, but that wasn't necessarily the first time, quote unquote, it came up.
I'm asking the questions. I'm not giving.
I just want to make sure the court's not misleading.
So you're objecting to his answer.
I'm objecting to the misleading nature of the question.
My question is, and I'll clarify, when was the first time you had the discussion with the prosecutor that you were going to arrest him anyways, so you were gonna find the contraband anyways?
No, today we discussed this and then I told him that he was going to jail regardless. That came from me. Basically, he was gonna go to jail regardless for this offense, the misdemeanor offense here. The money laundering didn't come until after started investigating the further possibility of seizing the money and going the route for filing the case for money laundering.
I understand that.
Okay,
You said that that came from you today, that you were gonna arrest him anyways.
yes.
So that's today, but today's not the first time you discussed that topic with the prosecutor.
So last week we talked that this case is going to trial, that he'd either meet with me,
Right.
and then we talked about it today.
Okay, so did that topic come up last week as well?
And that's my recollection.
It came up today in discussions with the state for the first time.
We talked, we moved to the report, cut it up the report.
Okay. And were y'all discussing that in context with whether it was a good search or not?
It was brought to my attention about some new case law that came out.
What case law is that?
I think it was, what was sent to me was a State versus Oregon or something like that in October of last year, but that was after this incident had occurred.
What does state versus Oregon say? I don't know.
Can I look it up and read it to you verbatim? Yeah.
You have it like in paper form with you or
No,
something?
it was on my cell phone.
Okay, go ahead. I'll do the same.
Because I think it was case in October 31st of 2025. about the
Oregon.
organ.
Oregon. Is that the dog can't stick their nose through the window of the car?
Continuously through the window, yes.
Okay. Dog can't stick their head through the car, that's a search.
It violates the Fourth Amendment, right? So basically, if the dog continuously sticks through there,
Okay, so if a dog sticks their head through an open window, that can be considered a bad search.
continuously.
And you got that case law when?
Probably the day before here.
The day before today?
Yeah, I was talking to K9 sergeants with Beaumont and the canine officer else here.
So you became aware of that yesterday?
What's today?
Today's Monday.
Either Saturday or Sunday.
Okay, and so who sent that to you?
The officer,
That, I mean, I've already, the dog part's done. Let's move on from that.
It does go to his testimony today, though, as to I was going to find it anyways, and I'm trying to determine where that idea came from, how it developed, and whose idea it was. You're including that.
He said that day, he is saying that he thought that it's been asked and answered. What I've heard is that he that day intended immediately that he was going to place him under arrest
Correct.
for the misdemeanor offense. And so that was,
Yes, I don't disagree with that. What I was trying to point out is, when was the first time that topic was discussed with the state of Texas, with the prosecutor?
okay, he's answered that as well.
Okay, yesterday. And that was because, I was trying to figure out, and then my next question was why? So the reason that was discussed is because in the last 2 days, the dog handler in this case sent you case law that called the search into question in this case. Is that true?
that's true. You can say that is true.
Okay, so that's when you first became aware there could be an issue with the search in this case, right?
Which I told her specifically, it doesn't matter because we all talked about out there that he was gonna go to jail regardless.
Okay.
For the misdemeanor.
I'm just trying to make sure that we're on the same page. That's when that discussion first occurred
Right,
with anyone other than yourself
right.
after the day of your
That was
arrest.
the stage with the other officer.
But that was this weekend.
Yeah, I'd say this weekend.
Okay. That's what.
I have no further questions with regard to that topic, Judge.
Okay. What I'm trying to find, and I believe but I don't have specific case law in front of me that I'm working on, is so. Obviously, I've already said what I feel about the dog and the search after, or the search being based solely on the canine. But I'm gonna go back to the other information that Officer Lopez had and used in developing what legally appears to me to be probable cause, whether or not he used that word or the word reasonable suspicion. And so the same things that I mentioned before with regard to what I believe legally creates probable cause would be starting off with the issue with the temporary tag and the fact that it looked photocopied, was laminated, the barcode did not work, is a jailable offense. Officer Lopez has tested under oath that he was going to arrest Mr. Green regardless, that the money was in plain sight and in increments that would be considered doper increments with showing signs and indications of drug dealing. And so Mr. Green admitted, that he had purchased the car on Facebook. Anyway, that gets to the other part. So with regard to, and then the other one, the other fact that I think is important is that Officer Lopez was part of the stop that the underlying cases that we're here for on probation for, and knew personally, Mr. Green knew that he was on felony probation for the offense of possession of marijuana, and that during that stop, there were indications of drug dealing, with regard to the scale, and other indications with surveillance on the house. And so, unless there is some specific, Mr. Galmore, unless you have some specific case law that would say that the officer's perception is the one that, not a reasonable person's perception for a probable cause would be, I would need to know that. Otherwise, I think the person, a reasonable person, a reasonable officer, the facts underlying would show that there was probable cause.
I don't disagree with that assessment. I believe the officer's subjective belief is not necessarily controlling.
Right.
I do though believe that it puts the facts that he knew at the time in the correct perspective.
Okay, so then at this time, I'm going to deny the motion to suppress. So then at that, let's go back to now, Mr. Coleman, you may proceed with Officer Lopez with any additional testimony.
Just a few really quick questions.
Sure.
Officer Lopez, back at the PD after you arrested the defendant, did you Mirandize or administer his Miranda warnings to him
He was at the jail, every, Miranda warning,
at the jail?
at the jail.
And did he waive those Miranda rights?
That's correct, yes, sir.
And did he offer an explanation as to the source of that cash?
He initially tried to say that he has a business of selling French bulldogs, and that I asked him, well, how many has he sold in the past year? He said he just started the business of and sold only one dog for around 1,200, which doesn't add up to the 20,000.
Did you search or did you learn through about his employment through any database or databases?
Yes, it's the TWC, Texas Reward Center. My supervisor at the time, Sergeant Sweat, submitted the request, and it came back that he hasn't had a job since 2023, and he had one check in 2023. I'm reflecting my notes real quick. That year, he only made $1,203.84.
How would you characterize his responses overall during your interview of this defendant?
He's very evasive. He kept saying I don't know to a lot of the questions. He did admit that he pays his mother's bills, which he couldn't explain where he gets that money yet to pay those bills. Asked him about his social media accounts where he sells his supposedly sells the dogs, and said he just created this the page. Overall, he just wasn't given. I felt like he wasn't being forthcoming.
Based on the totality of your investigation, all those things the judge ran down, the factors such as having that prior interaction with him for the drug arrest, the manner in which the cash was bundled, his interview, did you form an opinion? Albeit it's not the basis for the search or it's the judges found that basis, the canine search, that sniff was is not allowed. It still was part of your calculation, correct?
That's correct.
Okay, so based on all of those factors, did you form an opinion as to whether or not an offense or offenses was committed by this defendant? I know it's a wordy question. Did you form an opinion as to whether or not this defendant committed money laundering?
Yes.
And did you do so based on all of
Totality of circumstances. That's correct.
You also filed a chapter 59 Code of Criminal Procedure forfeiture action with the district attorney's office as it relates to that cash, correct?
That's correct, yes, sir.
I pass with the search.
Thank you. Mr. Galmore?
Along the lines of the fictitious license plate, did you, well, let's just talk about that real quick. Did you do any follow-up investigation after the arrest in this case as to that fictitious license plate?
No, sir.
You didn't do anything at all to try to determine if, well, first of all, Mr. Green told you that he got the vehicle in that condition, right?
That's correct.
He said that he bought the vehicle and it had that plate on it, right?
That's I believe that's correct.
Okay. Did you do anything to try to verify his story in any way?
like I had stated earlier, I asked him the question, so who he bought it from. A Hispanic guy that he couldn't even give me the name.
But he had a title
Yeah, title. Yes,
to the
correct.
vehicle
Yes, correct.
with prior seller's signatures on there.
Right, that's correct.
Did you keep a copy of it?
Let me refer my notes. I believe it was something good. I had it by hand. Yes, actually, I logged it in as evidence.
Okay,
The license plate and the vehicle title.
okay. And so to be clear though, you didn't do any type of follow-up investigation to any of those sellers?
No, sir.
Not even the last seller?
No, sir.
Now, as far as the money laundering, it sounds to me like you believe it's money laundering for two main reasons. Number one, his prior criminal history and your knowledge of it, right?
That's correct.
Okay, and number two, the way the money was bundled.
That's correct.
Basically, it's those two things.
Yes, sir.
Because we don't have any proof of recent drug dealing.
Well, running a criminal history, if you look at my report on criminal history, he was arrested again. I believe it was Chambers County for narcotics. So,
Chambers County.
Right.
Chambers County.
I didn't look at, but I know he's been arrested, a mile when I ran a criminal history, 1, 2, 3, 4 times for possession of controlled substance. And I believe that, yeah, so I believe the THC was possession, also it's been group 2 in Chambers County. If I can remember correctly. Yeah, that was 2024.
Do you know how many defendants were charged in that case?
Not sure.
Do you know if that was a traffic stop or not?
Not sure. It's just on the criminal history.
So I guess after you made those assumptions of his prior criminal history and the money was found the way it was found, you made that arrest. There was really no other investigation into the source of money besides that, right?
You mean that there's no investigation for
I mean, did you do any other digging after their arrest?
the money laundering?
Yeah, did your investigation end after the arrest?
No, I continued my investigation for the money laundering portion
Okay,
and later requested a warrant for his arrest. Filed that case with the district attorney's office.
okay. And then got the arrest,
That's correct.
but no investigation as far as any of the sources of that money.
At the jail during the Miranda warrant, when I read him the Miranda warning, he answered the questions. He was unable to tell me where he got the money from.
The total of $20,000.
It's 20,560
You mentioned he'd sold a dog.
for $1,200.
Okay. Do you remember anything else that he told you? Any other sources of money?
That's my recollection.
That's what it was.
Officer Lopez, about 18 minutes into that video, it's already been admitted to evidence. Would you disagree with me if I represent to you, it is clear a copy of that fictitious license plate appears on your video? You wouldn't disagree with me if I represent that to you?
That's correct. I wouldn't disagree.
And if this judge chose to, if she wanted to, she could watch that video and see the actual plate that you've been testifying.
That's correct. Yes.
Also, defense counsel said that you based your opinion on the prior knowledge of the drug offense and also the manner in which the cash was bundled, but that's not just it. You also interviewed this defendant, and that was part of the totality of the circumstances, correct?
That's correct. Yes.
And the tips of the commission records or lack thereof, that was also part of your investigation as well, correct?
That's correct. Yes.
That's what this judge.
Another question this time, Judge, subject to recall.
Okay, thank you, sir. You can step down. Don't leave yet, though, just in case. Do you need Miss Williams back, or was that primarily for the dog?
I don't think it's what is back at all.
Mr. Galmore, do you need Officer Williams for anything? Can we go ahead and let her be released? If you'll let Officer Williams know that she's released, you may call your next witness.
Now, this time, the state calls special agent David Park. And he will be a short witness. And also, Judge, I asked that this witness's testimony be treated not unlike the testimony of Miss Bradley, if, for purposes of punishment, if we get to that point. He's
Okay.
testifying about another,
Any objection to that, Mr. Gilmore? Do y'all want me to go ahead and make my findings and then real quick, and then we can put him on for punishment?
You're the fact finder. If the court can hear evidence and not consider it for purposes of revocation, we're not gonna object as long as you make a
I mean, I can, if y'all want me to, we can, if there's any other evidence with regard to revocation.
not from the state judge.
Mr. Gallimore, any other evidence with regard to
Yes.
revocation?
Yes.
Okay.
And I would hope that that would be after a break.
Okay, how long of a break?
I mean, 15 minutes. I just assumed that the court might take lunch at some point.
Well, I mean, if you've got court in another court, I had no idea that this was gonna be,
Right, neither did I.
when typically if we set it at 11, it's because I asked if it was gonna be an hour or
I
less.
certainly don't mind taking this witness right now for purposes of punishment only.
Okay, let's do that.
That's fine if the
Come on,
court
it's-
makes that notation.
Yeah, I'm gonna do that. All right. How are you, sir?
Good, how are you, man?
Good. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat.
Just to be clear, the court is hearing this testimony for purposes of punishment only if we enter that phase of this hearing.
Yes, and if there's something or a witness that needs to get here or be ready, if you can have co-counsel start working on that so that we can keep going, that would be great.
We will.
Okay, you may proceed.
You state your full name for the court reporter, please.
David Hyungsuk Park.
And Special Agent Park, how are you employed, sir?
I'm employed by Texas Department of Public Safety.
And you're a certified peace officer, no doubt?
Yes, ma'am. Yes, sir.
I'd like to take you back to January 12th of 2024 specifically. What capacity were you working at that time?
At the time, I was a Texas Highway Patrol state trooper.
And that day, did you have an occasion to be in Chambers County?
Yes.
And along Interstate Highway 10 at approximately mile marker 809, what, if anything, captured your attention?
There was a vehicle speeding on the interstate headed westbound. The speed limit was 65, and the vehicle that caught my attention was doing 95 miles per hour.
And did you effect a traffic stop on that vehicle?
Yes, sir.
Did you observe when you approached the vehicle any other violations of the law?
There were on the vehicle, the rear license plate was covered up, and it wasn't in a legal capacity.
The front passenger of that vehicle, which was occupied by a total of 5 individuals, but the front passenger specifically, who was he believed to be?
Front passenger was ID to be Mr. Green, the gentleman,
For the record, let's be specific, Ronnie Green III.
Brian Green.
And do you see Ronnie Green III in the courtroom here today?
Yes, sir.
Please point to him and identify him by article of clothing.
Gentleman wearing black sweater, black hoodie sweater.
I'd ask the record reflect the witness to identify the defendant, judge.
The record will so reflect.
Did you detect an odor of anything?
I detected odor of marijuana emitting from the vehicle.
Okay. And you're familiar with the odor of marijuana, the distinct odor of marijuana through your training and experience?
Yes, sir.
And did you ask for and obtain consent to search that vehicle?
I obtained the consent to search the vehicle by the owner of the vehicle.
And were there any admissions made by any of the occupants of the vehicle?
Most of the occupants, including the defendant, admitted that there was marijuana in the vehicle.
And pursuant to your search, did you just describe for the court what was found in the manner in which it was it appeared?
The green leafy substance with the distinct odor of marijuana was found throughout the vehicle, including the trunk and the back seat of the vehicle, and along with the THC wax, the tetrahydrocannabinol wax.
Now, we're talking about multiple bags of marijuana, correct?
Yes, sir.
Multiple bags of marijuana in various containers, correct?
Yes, sir.
My notes show that there were also envelopes. Was there substance or substances in envelopes?
In baggies, yes.
Okay. And did you arrest the defendant?
Yes.
Well, let me back up before the arrest. In the trunk, what did you find?
I found multiple baggies of marijuana, along with the THC wax I mentioned earlier.
What, if any, links to this defendant did you find in the trunk as it relates to the marijuana?
The defendant at the time, whenever I cuffed him and put him in my coworker's patrol car, he asked for his wallet. And I'm sorry, he asked for cash. He asked for the money that he had, and I said, along with the jar full of marijuana, and he agreed, and he admitted to have marijuana.
You prepare a report at or near the time when these events were still fresh on your memory?
Yes,
Did you review that report prior to testifying here today?
yes,
And did that help to refresh your recollection of the evidence?
yes, sir.
I'll pass the roll, sir.
Mr. Galmore.
Judge, if I could just have about 1 minute.
Yeah.
Okay, you stated that you made the pullover was based on the license plate,
The speed
it's speed.
violation.
Then you
Yes, sir.
noticed the license plate,
I noticed the license plate.
and it was because it was covered up with like an aftermarket, screen or something?
It was covered up with plastic coat, the plastic protective cover.
Okay. That is something you buy like Hilo or O'Reilly's or something?
No, it was like a regular plastic cover to prevent from dusting or any type of deteriorating.
Okay,
License
just,
plate.
it just made it a little harder to read, right?
Yes,
Okay, it wasn't an illegal, the plate was not fictitious, was it?
the plate was not fictitious.
Okay, it just was not supposed to have a darker covering on it.
It was obscuring the view of the license plate to read.
You stated that at some point towards the end of this investigation, that Mr. Green had sort of acknowledged that maybe some marijuana in a jar was his. Is that what you said?
I asked him if the money was next to the jar, and he agreed, and I found the marijuana in the jar.
Okay, so he is asking for money and you asked him, was the money by a jar?
Next to the jar.
Yeah. And then in that jar, you found marijuana in
Yes,
that
sir.
jar. Okay, so you believe that that means he must have known what was inside that jar?
Yes, sir.
Okay. Now there were other people charged with it as well, right?
Correct.
There were 5 people in the car?
Yes, sir.
You charged 3 people with what was found in the car?
Yes.
So not only did you charge Mr. Green, but you charged 2 other people with what you found in the car?
I would have to refer to my report.
Sure,
You
okay.
can.
While he's looking, Judge, was the date of this mentioned in his testimony earlier?
January 12th, 24.
Okay, just for the record, that was before this probation began.
Correct.
Yes, I placed all 3 subjects, including the defendant, the arrest for the offense.
Okay, so 3 out of 5 were arrested.
Yes, sir.
All charged with the same thing.
Same thing.
That's all I have, Judge.
Okay.
Nothing further for Special Agent Parkman. You need to speak.
Any objection to him being excused?
I know you're.
Thank you, sir. You're excused.
Thank you, Judge.
Say that's no further witnesses, state risk.
All right. Thank you, Mr. Coleman. Mr. Galmore, you need just a quick break. Do you have a witness?
Yes, I do have a witness and yes, if you just give us a couple minutes, maybe you have 10 minutes.
It is, 10 minutes. All right, back on the record. Mr. Galmore, you ready to proceed?
We are ready.
You may call your first witness.
Judge, at this time, the defense calls Ronnie Green.
All right, come on up, sir. Raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? You may proceed.
Thank you, Judge. Mr. Green, you've heard the testimony here today. I want to ask you about your car, okay? What were you driving that day?
Volkswagen Passat,
Okay, and when did you get that Volkswagen Passat?
like 3 months, a couple months before the arrest.
Okay. Approximately 3 months prior. You heard the officer say that he thought you told him about 3 months prior.
Yes.
Okay. Do you know who you bought the vehicle from?
No, I don't know him like personally. I know it was a guy, Mexican guy in this dark,
How did you find the car for sale?
through Facebook Market.
Okay, and you found the vehicle, and where were they located? Stellar.
I think it was maybe Texas City.
Where'd you meet him?
In like Winnie area.
Okay, where?
I think it's the like by Elites, with
Elite?
I think it's like it's a gas station.
Okay.
But I don't know the name of the gas station, but it's a place called like Elites Fun Place, I think it used to be.
Elise's fun house?
Yeah, I think so.
Yeah. I'm not talking about. Why did y'all meet there? Was that just halfway in between or something?
Yeah.
You got a title as part of that transaction?
Yes, sir.
Okay. Had you been to the title department yet to change title?
No, sir. I didn't know nothing about the transfer or anything.
Okay, but you had the title.
Yes, sir.
You gave it to the officer.
Yes, sir.
Okay. Since your arrest, have you gone to the department and changed that vehicle into your name?
Yes, sir. My grandmother did.
Okay, so now that's in your name,
Yes, sir.
and now you've got a legitimate license plate on it.
Yes, sir.
Okay. Did you put that fictitious license plate on the vehicle?
No, sir.
Okay. Who did?
That's how the vehicle. That's how it was given to me with the plate on it.
Okay. So when you got the vehicle, did you look at the plate?
Yeah, I looked at. I couldn't tell if anything was wrong with it or. There was nothing like that I could see that was wrong with it.
Okay, but you did not put that on there.
No.
Okay. Did you ever change the plate before you were pulled over in this particular case?
No.
Okay. Did you change the plate afterwards?
My grandmother did when she transferred the title
Okay.
of the car.
That same title that you had that you gave the officer?
Yeah, but they kept the last title, so my grandmother had to go and redo everything for the car. So she got a new title for it.
She got a new title?
Yeah.
And got it registered?
Yeah.
Okay. Is it in your name or her name?
It's in my grandmother's name.
It's in your grandmother's name. Okay. You told the officer as much information as you could about how you bought the car, where you bought the car?
Yeah, I even told him that I'm guessing the guy who I got the car from, like it was names on the title. I'm guessing he was the last name on the title.
Okay, so the last name of the title was a Hispanic man?
Yes, it is.
Okay, and you told the officer you bought it from a Hispanic man?
Yeah.
You believe that to be the seller?
Yeah.
I don't know. It's at the city right now.
You know, the videotape, we pull that up. Let's talk about your money for a minute, okay?
Yes.
There was $20,000 found inside that vehicle.
Yes, sir.
Was that your money?
Yes, sir.
That was your cash?
Yes, sir.
Okay. You say Ronnie Green that was arrested for marijuana a couple years ago?
Yes, sir.
Okay. You heard the testimony that the officer believes that was narcotics money?
Yeah.
Okay. Where did that money come from?
The money came from a few different places. Majority, I have a couple of cars, that I sold from Facebook Market. I had used to get pallets of furniture as far as like end tables, dining tables.
Let me stop you for a second. You said you sold some cars?
Yes, sir.
Is that normal for you to just sell cars?
Yes, sir. I use Facebook Market a lot.
Okay, but I mean, most people drive a car for a couple of years and sell a car. Were you selling a car more often than that?
Yeah.
Okay, so tell us, how often were you selling cars?
I didn't really keep a car for long. Once it started giving me problems, it was time for me to get rid of them. But probably about a year or so, say I keep a car. So
Okay, so from the time period of, let's just say you were arrested on this case in March of 2025, right?
Yeah.
Well, let's just say for 2 years prior to that, how many cars do you think you sold?
maybe 4.
Maybe 4?
Yeah.
Okay, will it explain that? Explain buying 4 cars, where you just bought a car, drove it, sold that car, and then bought a better car, or were you buying cars?
Yeah, or if it was something, that maybe needed to be like fixed up on the car, but kind of get it and fix it and kind of profit off of it with the resale.
Okay, so you'd buy a car, just run down.
Yeah.
Drive it, work on it, and then eventually sell it
Yeah,
for a markup,
yeah,
and then go buy another one.
yeah,
Like a house flipper, but a car flipper.
yeah,
Okay, and you think over a 2 year period before this arrest that you might have done that 4 times?
yeah, 4 cars.
Okay. Um, did you also sometimes sell other things?
Yes, sir.
Let me. Well, I go ahead and disorganize, so give me a second. Okay, I'm handing you what I'm going to eventually mark as defense exhibit number 1. Let's just look at that for a minute and just tell me if you recognize that.
Yeah, Mark, you go ahead and get the sticker.
Yes, I'm with it. All right, I didn't like the way this is organized, so I decided to change it up, make it easier to admit.
Okay.
You didn't do that. This. So you recognize those documents?
Yes, sir.
Okay, what are those documents without reading the documents? What are they?
Facebook market listings.
Okay, and are those Facebook marketplace listings that you have placed in the past?
Yes, sir.
Are these marketplace postings, generally speaking, within about a 2 year time frame before your arrest?
Yes, sir.
Give or take?
Yes, sir.
Okay. Are they the same ads that you placed? Have they been changed in any way?
No, sir.
And these are the records that you kept as part of keeping records of selling vehicles.
Yes, sir.
Is this a true and correct copy of those advertisements as you placed them?
Yes, sir.
Does it fairly accurately reflect those advertisements when you post them?
Yes, sir.
Let me hand these back to you real quick, but let me make sure we've got the same thing. You got 5?
I'm still looking at what you offer in the marked.
I got you. Okay, so would you look at those documents and confirm with me, are you have 5 vehicle transactions?
Yes, sir.
Let me see the back. There's a duplicate in there. So look at that again. See how many you look are in there.
4.
4. Go ahead, tell me which 5 vehicles you sold in that time period, the 4 vehicles you sold during that time period.
A 1996 GMC 1500.
Okay, and what do, let me stop right there. Judge, at this time, I'm gonna go ahead and admit defense exhibit number 1 in the evidence. I believe I've given prior to.
Is multiple,
It's gonna be 4 advertisements are all part of Defense Exhibit 1. Well, he got the actual copy, but that's the same thing anyway.
Judge, no objection, based on this defendant's sworn testimony to be true and accurate.
States one is admitted.
We'll make sure he's legal. Yes.
Defense one, sorry, thank you.
Oh, no, you gonna use the Elmo?
Uh,
I mean, because I'd rather work from the ones that you marked.
we'll use these.
Okay.
Okay, I'm gonna hand these back to you now. So that first vehicle, what'd you say which was, the 1500 Chevrolet?
Yes, sir.
Well, what's that sheet up there?
Something else.
Just so it doesn't get mixed up. Thank you.
And so you sold was it a Dodge Ram 1500?
Yes, sir.
Okay,
2001.
and
Hold
approximately how
on,
much?
and so what, the first one was a 96 GMC 1500.
Let's start with that one. 96 GMC 1500 regular short cab.
Yeah.
And do you remember how much you sold that for?
2700.
Okay. It says there in the ad, you had lowered the price to 2700.
Yes,
right?
sir.
Okay. And then another vehicle was a 2001 Dodge Ram 1500.
Yes, sir.
Okay. And do you remember what you sold it for?
2250.
Now, 2250 was your lowered asking price. Is
Yeah.
that what they ended up giving you?
Yes, sir.
Okay. Another vehicle you sold was a 2013 Chevrolet Cruze, right?
Yes, sir.
And do you know about how much you sold that one for?
1800.
And the last one was the 2007 Pontiac Grand Prix sedan. And how much you sold that one for?
1800.
Now, what would you do with the how, first of all, how were you paid for those vehicles?
Cash.
Okay, was that pretty good? Whenever you sell a $2,000 vehicle, that people would pay you with cash?
Yes, sir.
And what would you normally do with that cash?
Majority of it, I had like a purified water jug.
A purified water jug?
Yeah, like as like a piggy bank where, I put the money in and save it and couldn't take it out. Like
Okay.
that kind of
So
thing.
you kept the cash stored at home?
Yeah.
In a plastic money jar,
Yeah.
like one of the big 5-gallon.
Yeah, it was like a savings thing. I couldn't pull any money out of it unless I cut it off.
Now, you also sold some other items on Facebook on occasion,
Yes, sir.
okay? Would you normally, when you sell those items, would you normally receive cash for those items as well?
Yes, sir. And I have also received cash out for those two.
Okay, and it looks like, while I'm assembling these in a better order, it looks like some of the things you sold were maybe an air conditioning unit.
Yes, sir.
You sold a generator.
Yeah, plenty of generators. I go and get like 5 and 9 at a time.
How many air conditioners do you think you sold?
Only that one.
Only the one that's in this advertisement.
Yeah.
Okay, but generators, you said you sold more than one generator.
Yes, sir.
Okay, how many do you think you've sold?
Probably like 12 to 15 of them.
Okay, what do you sell those for usually?
The lowest between 250 to 650.
Okay, just depending on the size of the brand of the generator.
Yes, sir.
Okay. I'm gonna hand you what's been marked as defense exhibit number 2. Do you recognize those documents?
Yes, sir.
Well, are those the advertisements from some of the things you sold prior to your arrest in this case?
Yes, sir.
It's the generator and the air conditioner things we discussed.
Yes, sir.
Okay, and are they still, are those advertisements, is that a printout of the advertisements you actually placed?
Yes, sir.
And you kept those as part of selling things?
Yes, sir.
As receipts, basically? And they haven't been modified or changed in any way?
Not at all.
Fairly and accurately represents the ads you posted?
Yes, sir.
Okay, this time, Your Honor, Met what's been pre-marked for defense exhibit number 2.
No objection to this, so long as this defendant's sworn testimony that it's true and accurate.
States two's admitted.
Now, on this particular ad in defense exhibit 2, it says out of stock because you did no longer had any.
Yeah, well, yeah, I no longer had that wattage, that size.
Okay. Where would you get these generators from?
Houston,
Okay. Where at in Houston?
Cypress.
Okay, and was this some kind of, what name, describe the facility where you're buying these from?
Well, it's basically they have a bigger warehouse, but it's kind of farther away, but they have a couple of locations. It's actually a storage unit in Cypress and generators with cell generators, air compressors, working equipment.
And so you're getting these at wholesale?
Yes, sir.
Are these generally cheaper Chinese products or something?
No, these are Predator generators.
Okay, I'm not familiar with Predator. What does that mean?
It's like a good brand that everyone likes.
Wait, is Predator sold at Harbor Freight?
Yes, sir.
Okay, I know what you're talking about. And so you sold a variety of those?
Yes, sir.
Okay. All right, so these last things I've got here are some bank records that we've looked at together, correct?
Yes, sir.
Yeah. And it looks like they're all from the 5 Point Credit Union. Is that where you bank?
Not anymore.
Not anymore. But this is where you've had a bank for some period of time leading up to the arrest in the.
Yes, sir. It was before I started a business bank account.
Okay, so this is about 2 years worth, it seems, give or take.
I think it's two, three. Yeah.
And it's the 2 or 3 prior to the arrest in this case.
Yes, sir.
Now, I'm not gonna bore everyone with all the details of every single statement, so let's just, well, first of all, let me hand you this. I'm gonna call this defense exhibit number 3. Right, here we go. Are those your statements, your bank statements,
Yes, sir.
for your account
Yes, sir.
that you receive from the bank?
Yes, sir.
And you keep them as part of your financial records?
Yes, sir.
Have they been changed in any way since you've received them?
No, sir.
Okay, are they true and correct copies of your statements?
Yes, sir.
Do they fairly and accurately reflect the transactions in your account?
Yes, sir.
So on page. Okay, Your Honor, at this time, defense would tender defense exhibit number 3.
I'd like to take a look at those. Yes, please.
And I don't have a separate copy. I don't really need them if you take time. I didn't have those. I was getting those a minute ago. In here, okay, for purposes of expediency. You had some money put into these in this account, right?
Yes, sir.
You paid some bills out of this account
Yes, sir.
and you've received cash out of this account,
Yes, sir.
okay? Sometimes I guess whenever you receive money, that it was not in cash, how would that be, a check, cash app? How would you receive money for that account that was not received in cash?
Well, I have received a check or two and yeah, cash out.
Cash app,
Yeah, and Chime also. I also use Chime.
China. So you've got money coming into the account electronically.
Yes, sir.
And so you would then sometimes take cash out of the account?
Yes, sir.
Okay. And over a 2-year period, you took out cash on several occasions over a 2-year period, right?
Yes, sir.
Let's see. Okay, so I'm gonna just go over some notable ones without going to all of them. It appears that you've made some deposits. I mean, some withdrawals for cash. You made $1,200 withdrawal in August of 2024. Thousand and another thousand in August of 24.
Yes, sir.
2,500 in October of 24.
Yes, sir.
Those are all after this offense.
October.
Oh, you're talking about, I'm sorry, after the probation, carry on.
Right, because March.
No, you're right, just
Okay,
ignore what I said.
okay. 1,700 in January 25.
Yes.
1,000 January of 2025.
Yes.
And then you've got a lot of withdrawals for 200, 500, 700, variety of withdrawals over time, right?
Yes, sir.
If I told you that if I did the math, looking at cash withdrawals on your statements, that totals to be approximately 19,700 and change, do you have any reason to believe that that number is wrong?
No, sir.
Okay. But that's not at one time, that's over a couple of year period.
Yes, sir.
Okay, and then you would, what do with that cash?
The water, the jug,
Okay, why you like keeping cash in your water jug?
I just feel more safe with the money, you know, with me. It was like a challenge that I do for myself of how much could I put in the jar, like in a certain amount of time.
Okay, well, you didn't have $20,000 in a water jug.
No, not at one time.
See, but I'm saying at the scene, when you were arrested with the $20,000, it wasn't in a water jug, was
Oh,
it?
no, sir.
Okay, why didn't you have it in your water jug?
Because at that time, the challenge to save the money, it was over.
Okay, what do you mean?
I gave whenever I used the jug, I gave myself a like certain amount of time. Every day I put the money that I have in cash, or if I go work or sell something, I put it in the jar.
Okay, I guess my question is, why did you need $20,000 on you at that time?
Because I was originally going to take it to my bank, but I let my dog out. I let my dog out before I left, and the neighbor next to me told me that my dog had ran across the highway. So that's how I end up way somewhere else with the money. And
Wait a minute, let's back up. Okay, so you're saying you were taking that money to the bank?
Yeah.
Okay. What, the same bank that we were just looking at the bank statements?
Yeah.
Point credit.
Yeah.
Okay. But you didn't because of the dog.
Yeah, I let my dog out before I left, and I was told that he ran across the highway. So that's how I ended up taking a detour somewhere looking for my dog, which was to my grandmother's house. That's where I was pulled over from.
So you were looking for your dog when you were pulled over?
Yeah.
Okay.
And that there's also whenever I end up being incarcerated, my dog was posted on Facebook, you know, that some people had found him and he was returned.
Okay, did you tell the officer that?
I think so. Yes, sir.
Okay. Just to be clear, only addressing the allegations in the NTRP right now with this particular witness. If the court were to make a finding of true, I would reserve the right to call that witness again in the future, because we're not doing a punishment hearing right now.
Well, we're kind of doing everything right
I
now,
understand.
so you might as well.
Give me 1 second.
I mean, we can have them sit down and go back up if I need them to, but it's up to you. I feel like I'm going to need to probably see a video. I don't know how long that's gonna take me to review, but if he says he's told the officer that, then I'm gonna need to see, I wanna watch the body cam to know if that's a truthful statement or
I've
not.
had the minutes interview saved seven.
Well, I would like to know, well, I guess I need to watch, he didn't say when he said it, but they talked to him on the side of the road and at the station. So anyway, Mr. Coleman, for purposes of You can recall them later if you need to for.
I'll ask the witness.
Go ahead, Mr. Coleman.
Green, I'll be brief. You understand as the operator of that Volkswagen, you're responsible for the condition, the legality or illegality of that vehicle under the law. You understand that, correct?
Now, yes, sir.
Okay, and you understand if the tint's too dark, then you're the one that's gonna get the ticket. You understand that, right?
Yes, sir.
If the windshield has a crack in it, no matter if you just borrowed it or just bought it, you're the one that's gonna get the ticket, correct?
Yes, sir.
The brake light is out, you understand you're the one that's responsible for it, right?
Yes, sir.
And likewise with the fictitious license plate, you're the one that's responsible if you get pulled over as the operator of that vehicle, correct?
Yeah, now, yeah, I understand that part now.
Very good. You understand you're under oath, right? And you're sworn to tell the truth, and if you're not telling the truth, you've subjected yourself to aggravated perjury, which is a whole another criminal charge. You understand that?
Yes, sir.
With that being said, you did not tell Officer Lopez anything about buying and selling pallets of furniture, did you?
I don't. I may have on the side of the road, and we talked on side. I was on the side of the road for a little minute, and
Did you say anything to Officer Lopez about buying and selling generators?
no, not about the generators.
Have you brought with you today any receipts or sales documents, transfer documents with you to substantiate these sales?
My bank statements and the marketplace listings.
Does the bank statements show who you sold these objects or items to?
No, sir.
Does the Facebook postings here from the marketplace show who you sold these items to and how much money they paid?
Not currently on the copy, but I do have messages. There's messages there.
So that's a no, right?
No.
Okay. And did you bring any of those messages with you?
No, sir. From my understanding, my lawyer.
That's a yes or no question. Thank you for answering it, yes or no. My investigator, you understand, the district attorney's office has investigators who are law enforcement officers who can verify the things that you're seeing, right?
Yes, sir.
Okay, so in order to help us maybe potentially verify this, I'd like to know, for the purpose of my investigator here, what phone number is associated with that Facebook Messenger? When you post things on there, do you use a cell phone or do you use a computer?
I use a cell phone.
What phone number for that cell phone number post did you use?
There's no phone number. They message me through Facebook Messenger.
Yeah, and I get that. And even me, as technologically deficient as I am, I still understand that you first have to post something for them to message you back. Isn't that how that works?
Yes, sir.
Okay, so tell me what device and the phone number associated with that device did you use to make the initial posting, please?
At that time, I think it was the number is not the same anymore, but 409 332 0008.
409-332
0008.
0008. Any other phone numbers that you use to make these postings of cars and generators and furniture pallets and that kind of business? Any other numbers?
No, sir. I mainly use Messenger.
Okay, let's talk about the Messenger. When you used Messenger, did you use your cell phone or did you use a computer?
My cell phone.
And is that the same 409-332 0008?
Yes, sir.
Who was the carrier at that time? Cell phone carrier.
I think Spectrum.
You think, or are you not sure?
I think it was Spectrum. I didn't personally buy the phone.
Whose phone?
The phone wasn't in my name.
Whose name?
My aunt had got it for me.
Whose name was the phone in?
My aunt Raven Green.
So the phone number of 409-332 0008 that you used to make these Facebook marketplace posts was actually in Raven Green's name.
Yes, sir.
And Raven Green's phone carrier was Spectrum.
Yes, sir.
All right. The account name that's associated with that Facebook Messenger account, what was that account name?
Rodney Green.
Rodney?
Rodney Green.
Rodney Green, his name was on that account number. Who is Rodney Green to you?
his name, Ronnie Green.
No, I thought I heard Rodney.
No,
But
Rodney.
Rodney,
Yes, sir.
okay, I'm sorry. Rodney, okay, I think that's all I need on that. What about the French Bulldog that you told, Officer Lopez that you sold? Did you bring a copy of that Facebook, marketplace posting?
No, sir.
All right, the, bank records that we've looked at, that I glanced at previously, there were months when there was a balance of as low as $5 at a time. And isn't that fair to say?
Yes, sir. I think when I first opened the account.
Oh, no, where's that? Is it? It's up there. The bank records?
Bank records.
I'm looking at state's exhibit number 3, the,
Defense exhibit.
thank you, Judge.
You're welcome.
Defense exhibit number 3, make sure I get the right month here. Oh, the month of December of 2023 shows a balance of $7.38. Would you dispute that?
I don't know. I don't know what you mean by dispute. But
Do you disagree with that? May I proceed, Judge?
You may.
We're looking at a bank balance from December of 2023 that says there's a balance in that account of $7.39. Would you agree or disagree?
yes, sir. I think that's when I first opened the account.
Okay, fair enough, but you agree.
Yes, sir.
All right, now we're looking at a statement from November of 2024, and it shows a bank balance of $5. Would you agree or disagree?
Yeah, I think that's more like.
It's a yes or no question, Mr. Green. Is there a balance in this account in November of 2024 for $5?
Yes, sir.
Okay. Now we're looking, I'm gonna skip through these. I think I'm kind of made my point here. April of 2024, a balance of $5, right?
It says the beginning balance.
It also says ending balance there. What is the ending balance, Mr. Green? It's not a trick question.
It says it's $5.
Just pick one last one for good measure here. January of 2025, it shows a ending balance of $5. Wouldn't you agree?
Yes, sir.
Thank you. The cash app that you use to make these transactions, did you use the same phone number? The 409 332-0008
I
number?
think I used the email.
What was the email associated with that cash app?
greenronnie95@gmail.com.
No further questions, Judge. I'm happy.
Just one real quick one, just for clarity, Mr. Green, the reason why you had a low balance in that account, generally speaking, is you would not leave money in, you would typically take the cash out of the bank account, right?
Yes, sir.
Keeping it on.
Yes, sir.
Okay, pass the list.
I've never further, Judge.
Hold on. I have a question, or 2 or 3. Why was the money wrapped the way it was?
In the rubber bands,
Mm-hmm.
so that I can know how much it is. That's how I separated the money. Cause I didn't have like any bands, that the paper bands or nothing, so I used a rubber band instead of a paper band.
All right, go ahead, have a seat. Any other witnesses? Any other witnesses, Mr. Bell?
I don't have any other witnesses. The court stated that the court was wanting to watch a video though.
Well, I guess he said that he thinks he said it on the side of the road.
I looked at my notes and just for clarity, I do have a note, or it's in discovery. That at the time when the officer was asking him about why he had the money on him, that he explained that he was taking it from one location to another. I think to the grandmother's house, I think is what he was trying to explain to the officer. So if, I think that may be contained on the video at the jail where the officer's asking him where it was going, if that's what the court's talking about.
Well, that's one thing. So, so if he said then that he was on the way to take it to his grandmother's, that's
I think he used an address.
inconsistent with taking it to the bank.
My grandmother had to come.
I may have said that wrong, Judge. I don't want to put words in his mouth and I don't want to summarize what he would tell the officer. While we were operating a minute ago, you made the comment and I was trying to locate.
Well, I guess because
Discussion.
so what I want to know, I mean, I guess what I'm trying to look for is anything that would explain or show consistency or inconsistency with the statements that he's talking about today. Because from what I can tell, Officer Lopez, in his testimony and what you guys looked at in his statement or his police report, as well as the defendant's interview, no one has said anything about cars, air conditioners, generators. No one has said anything that he said anything about going to the bank. So if he said he was going to his grandmother's, then he said he was going to his grandmother's, then he said he was going to the bank here. There wasn't any testimony that he told the officer about the dog. So I want to know if there's anything that he told Officer Lopez about the dog being lost and he's looking for the dog and that's why he wasn't going to the bank. I want to know when he was in the interview, when he specifically testified that he talked about he saw one French bulldog, that they checked the Texas Workforce Commission and that he pays his mom's bills, but there was nothing unless he forgot to tell us here on the stand and he's still here. We can get him back in.
I think there's two ways we could do this, Judge. Obviously, I think the traditional route in front of a jury would be with all the videos were just played in front of the jury as a fact finder. I think both sides were trying to avoid just playing videos for fun.
I would love that.
If the court would give us brief, since we're not going to trial next door, if the court gives us a little time, we'll go and watch the videos and then can submit.
Why don't we get Officer Lopez back in since he's just sitting out there waiting? Let's at least ask him if he has any recollection of that. And then if he doesn't recall, everybody can watch the video and go from there.
Okay.
Yeah, I do.
Oh, that's right.
You can come on up and have a seat. Do you guys want to ask a question to clarify? Do y'all care if I do?
I'll defer to the court.
That was the question.
Do y'all want to question Officer Lopez or do you care if I ask him the clarifying questions?
That was in line.
So Officer Lopez, I wanted to ask if you recalled anything else from, well, let's start with when you first had Mr. Green on the side of the road. And we can watch your video. We might have to do that, but I want to see what your recollection is. Do you recall where he told you he was going and why?
Well, I was just reading that.
And you're welcome to refer to your report if
Okay.
it's in there.
So I remember he said he was going to Paradise Apartments, which is off of Memorial Drive. I think that area.
Did he say what he was going there for?
I'm not really freaking on those to remember. Okay. So he told my partner, Officer Peloson, that he was going to Paradise Apartment, but during the interview at the jail, he told me he was living at his grandmother's residence on Evergreen Drive.
That he was living at his grandmother's?
He was living at Okay, so basically said that Green said that he was transporting the money from one location to Paradise Apartment on Memorial, but did not know which apartment. Um, then he had told my partner that he lives in Paradise Apartment. But during the interview, he told me he lives at his grandmother's residence at Evergreen Drive. So basically it was conflicting of where he actually lived.
Do you recall him saying at any time, side of the road or in the interview, that his intention was to be taking that money to 5 Point Credit Union or any bank?
No, not the my recollection at all.
Did he mention to you anything about having the money bundled or why it was bundled that way?
Not to my recollection.
Did he mention to you that it was because he was taking it to the bank and that way he knew how much it was in the increments so that he would know how much he was giving the bank? Okay. Did he mention to you ever on the side of the road or during the interview, anything else that he had been selling in the past to make money other than that French bulldog? Did he mention, do you recall anything about generators? Do you remember anything about pallets of furniture?
No.
Do you remember anything about, did he tell you that he would buy cars and then resell cars on Facebook Marketplace?
No, ma'am.
Do y'all want me to watch the video or y'all okay? Anybody want to question or have any other questions of Officer Lopez at this time?
Questions, Judge, and I don't know what more the video would offer, but you're certainly welcome, Judge, if you like.
No, I mean, his recollection is, Mr. Galmore, do you have any other recollection from watching the videos? Y'all both watched them.
Right. My concern is that there are some contextual statements that might be made that might help point one direction or the other. And if the court's not wanting to watch both scenes, the jail and the arrest, the arrest location, with just a little bit of time, I can see if there is something worth submitting to the court or not, in order to avoid watching all the video for no reason.
Well, I mean, at this
Been
point,
admitted. Actually, it's been admitted.
no, I know it's, yeah, I mean, and if, but if, I mean, obviously from Officer Lopez's responses and surprise at some of my questions, I don't think there's anything, he seems to remember pretty well this stop and arrest. And so, I mean, if there's something else that you know of, that's fine. If not, I'm good.
If there is nothing else, I don't intend on calling any other witnesses.
Can we allow Officer Lopez to be excused at this time?
His video's already been admitted,
Yeah.
and even if I found some statement that he made, I would not need this officer for that.
Thank you for your patience today. You're free to go, sir. All right, so let's go to then argument with regard to whether or not the allegations are true or not, and then we'll discuss what we need to after that.
Are you gonna hold the ruling on advance until we review and see?
If you don't have anything in your notes that spurred your memory at this point, I mean,
I do very specifically remember some of his answers. I would have additional argument to make as far as what his intentions were, but I can't do that without seeing it again specifically I don't want to misquote what I remember. But I also don't want to play on the video for no reason for the court. If it's not really going to be that helpful, I don't want to repeat it. I don't want to argue something that's really not that strong of an argument. The court's got it before it.
okay, so let's do this. I'll give you 15 minutes.
Okay.
We'll get started at about 10 after, see if there's anything else that you need me to see at that point. We'll be in a short recess. You don't want to see me at 5:30 if I haven't eaten. All right, so we're back on the record. State's attorneys present, Mr. Galmore and Mr. Green. Mr. Galmore, is there anything that you think would be important for me to watch? Is there
Yes.
something you want to?
Yeah, Judge, I've said in the court a lot of time, we're just gonna watch a very
Perfect.
short piece of the stop.
Okay.
And we're on the record?
Yeah.
Okay, so
You need to switch it to, switch the Elmo to the other, input, please. So it shows on the screens. There you go.
learn from the best. Dude.
You have no idea.
All it took was one button.
He's come a long way. All right, go ahead.
So Judge, the reason why I'm playing this portion of the video is this is what the defense would believe would be his initial answers in reaction to the officer, probably more important than anything else.
Okay.
And so this is gonna be his off the cuff answers that he's gonna give this officer when he's first pulled over. And for purposes of record keeping, I'm starting the video at about 20 seconds. Oop, change the speaker. You want?
It should be fine.
I
No, it-
changed it so I could hear it without everyone listening a minute ago, so come look. No, come look, come look.
No, I don't.
I'll change it back, but if you click on the speaker.
Yeah.
And then you click on the little buttons by the speaker.
Okay.
Then you can select which speakers they play on, and
Alright.
I'll put it back on.
Alright.
No overhead, there you go.
It's kind of weird. Hey, you know what? I'm Officer Lopez, Florida Police Department. You have your license insurance on you? Hey, we're behind and I ran your plate and it shows to be expired in March of 2023, even though it says April 13th, 2025 on it. When I ran the plate, it comes back, it expired like 2 years ago. Where'd you get the plate from? Where'd you buy the car at? Facebook Market. Do you know, is it a company? It was some dude that's put, is that where you got a license plate too as well? You doing all that money down there? Where you work at? Oh, you sell dogs? Okay. You got an idea on you?
Mr. Gilmore, pause that for a second. Can you get the TV remote? It should be right over there. Hopefully the first one. See if you can turn that sound up. It's set up.
Let me see if it's all the way up here. It's not all the way up here.
Let's see if we can get, yeah. And then go back a little bit. Oh, well,
Do you know what, is it a company? No. It was some dude that's put, is that where you got a license plate too as well? Yeah. You doing all that money down there? Where you work at?
I sell dogs.
Oh, you sell dogs?
Actually, just monster dog. I've been running around.
Oh, okay. You got an idea on you?
Judge, I'm not playing anymore. Yeah, if the court wants to hear more.
I didn't understand some of what he said after he said he sells dogs.
So if I just, I think it'd be handy to have him clarify that for the court. And so I'll call him and ask him questions related to this video right here.
I mean, do y'all know what he said?
I do.
I find it hard to make out, so.
You know, what I believe he says is I'm lost a dog and I'm out here looking for it. I've been out here looking for it.
Oh, I heard that, yes.
Okay.
I would concede that he said that.
Okay, and that he was taking the money to,
He did say he was taking the money home.
okay,
Now, the reason why I want to have him maybe clarify some of that is because there's this, the officer was confused. There's 2 addresses he talks about it being home. Because he actually has an apartment and he has a grandma's house. He kind of resides at both.
but he didn't say he was taking it to the bank.
Correct.
Okay.
That's correct. But I want to have him kind of give the entire context of why he gave those answers, and that's all I have him testify to. Is
Like
why he gave those specific answers.
Judge, I've
I think
conceded.
he already did.
Yeah, I've conceded, and
Well, but not why necessarily, because like the question the court just had was, he did not say he was taking the money for the bank.
Well, I know, but now he gets to get up there and know that what I'm concerned about and explain. I don't need any other explanation. I don't think. I think that just is almost a little bit unfair. Where
I
he
can say
sits and listens to everybody, and then he gets to get up and say,
Well, this had already been admitted in evidence. It wasn't like it was a witness that he got an opportunity to hear from. He's never gonna hear from. This is always known. What he said on the video has been known to him and
right.
in the whole time. So it's not like he's heard something new. He's gonna change the story. I mean, it's the same thing he testified to
But
earlier.
he just testified earlier that he was going to the bank.
Correct.
So that's his testimony, that he was gonna go to the bank, but his dog got out. He played that to the officer, so he was doing something else.
Looking for the dog.
Okay,
Right. what, if the court didn't want to hear from him, that's fine. What my argument will be, and what he would say if he took a stand right now, is that he was originally taking the money to the bank. But when he lost the dog, he's been spending time with the dog, he was no longer going to a bank. So that was not his intentions anymore. At the time he was arrested, he was no longer going to a bank.
Okay,
I have a problem with that proper, if that's his proper.
that's fine.
That's what it's fine, we'll testify to,
Sure.
I'm okay.
Okay,
The reason I wasn't testified to earlier is because this portion was not heard, and it just never was explained.
okay.
No.
Okay, so now with regard to true or not true, very brief argument.
And I heard you, Judge, you heard the testimony, and you can gauge the truthfulness or the lack thereof of the testimony, Judge. The state maintains that, well, let me start with the low-hanging fruit. The defendant, I think it's clear, by, beyond hundreds of the evidence that he committed the offense of having that fictitious or wrong, license plate, the state, that can find that in and of itself is a violation of the state law. As it relates to the money laundering, Judge, you've heard the defendant's testimony, you've heard the changing, the shifting, quite frankly, the untenable testimony of this defendant about the nature and origin of that cash. A version today in court that was different from the version that he told the officer during the interview. And I think they go straight to the heart of his truthfulness and believability, Judge. Along with the other circumstances, the way it was bundled, and the previous arrest with the drugs, with the scales and that kind of business that lend itself to a drug transaction, Judge. We think if we get there, we'll be out of preponderance of the evidence in this case, Judge. Based on that testimony and the evidence, we'd ask the court find that the defendant has violated his conditions of probation by committing money laundering and also by committing the offense of having a fictitious or wrong license plate.
Mr.
Yes, Judge.
Gilmore,
Number one, I'd like to point out, at least my understanding, and maybe I'm wrong, but in order to commit the offense of fictitious license plate, he would need to be proven, in order to be a Class B misdemeanor, would need to be proven, that the owner knowingly altered or made illegible the letter, numbers, and identification marks, in which case it'd be a Class B misdemeanor. So
so where do you get,
I'm looking at statute is
504945?
correct, 504-945, and what they have alleged.
The way I read it, and maybe I'm looking at, it says a person commits an offense if the person attaches to or displays on a motor vehicle a license plate that, and then there's A1 through 7. It does not say the owner, it says a person.
Right, I don't disagree with that. I think there are two offenses though, so I believe what the normal statute is actually a Class C misdemeanor. But it becomes a Class B, if you look at,
See, and this says other than
E and F.
Other than E and F, it's a Class A. Oh, I'm sorry, misdemeanor.
Right, punishable by 200 or less.
Okay,
So that's Class C. So the only way it becomes higher than a Class C is it says if it's shown that the owner knowingly altered or made illegible. Basically, it's saying that proving that the owner did that is what I read that.
well, A4, okay. A4, well, there's two different sections or that I think could potentially be potentially applied to this case. So you've got A3 is that the person displays a license plate that is assigned for a registration period other than the registration period in effect. And then you've got A4 that says it's fictitious. A4 is one of the exceptions, making it a Class B misdemeanor. I would agree that A3 does not appear to be an exception and would potentially be in Class C. Does that?
Yes, I
Okay.
agree.
So.
Yes, I see that.
So, with regard to the testimony, I really think probably either of those could apply. The fact that the barcode did not work, and that it appeared to be a photocopy and not a real even tagged plate. I think it could be easily under 4, which is fictitious, which would make it a Class B misdemeanor.
So under both of those theories, if we're gonna just say that's the theory that the government is pursuing here, even though there is not a mens rea alleged in the statute, it's my understanding that the way the law works is that if there's not a specific mens rea alleged, then it always has to be at least intentional, knowingly, or reckless finding. I don't think negligence is allowable when it's not specifically stated in the statute, but it's not a.
And all that might be different because it's transportation code and not penal code.
Understand, I still think that the government has to prove knowledge. So if the court believes.
Well, the
that-
statute doesn't say, and just like, so if we're gonna treat it as if it were a penal code statute, then every statute in the penal code says a person intentionally or knowingly, a person intentionally or knowingly or recklessly or with criminal negligence. This does not have in this statute anything, which I don't think means that I myself then require some specific mens rea, because I don't know which one I would require. It's not in the statute.
The state's position is that it's effectively a strict liability statute.
Yeah.
Either you're operating that vehicle that displays a fictitious license plate, or you're not.
Okay, so Judge, under Penal Code Rule 6.02B. Hold on, what it basically states is that when an offense does not specifically describe culpable mental state, a mental state is nevertheless required unless the declaration plainly dispenses any mental element.
But that's an offense into the penal code. So the transportation code, does it have any like statute that has some definition of, you know what I'm saying? I mean, that
Yeah.
obviously applies to the penal code, but if the transportation code doesn't have anything like that, then I don't think I'd take one from the other and require that application.
Well, I was summarizing, and I may have used that word, if 6.02A states, unless a person does not commit an offense unless he intentionally, knowingly, or recklessly, or with criminal negligence engages in the conduct as the definition of the offense requires.
And this definition,
Prescribe one, it's nevertheless required unless the definition plainly dispenses of any mental element. That's B.
so I mean, I can find whichever one,
I mean, it is.
you know what I mean?
Right,
So,
not strict liability. The government mentioned earlier, this offense is strict liability. There is no strict liability for criminal offenses.
but this is, but I'm, again, I want to make sure that we're not comparing apples to oranges, because we're talking about the transportation code and the penal code. 6.02 is within the penal code, and it doesn't say this, you know, this applies to, and I think it
I
would
mean, it
be,
says an offense. It just says an offense. It doesn't say where it comes from. To be fair, I don't see where it says it has to be from the penal code. Some offenses come from the water code, although rare. Some come from some other.
and they
codes,
have their
although
own
rare.
definitions and their own mens rea, and all of that is typically included in those statutes. You know, including in. So, I mean,
I will say that just along those lines, it does say at the very bottom of F, it says an offense defined by municipal ordinance or by order of county commissioner may not dispense of the requirement of a culpable mental state. If the offense is punishable by a fine exceeding.
but if you're speeding and you say, I didn't know what the speed limit was, that's on you. You're gonna get a ticket. You don't get to say, I didn't know what the speed limit was. That's a
That's correct.
transportation code. So I don't think I'm not going to take the culpable statute 602 and penal code, because it does not apply in many of the the transportation code offenses.
But wouldn't the person who's,
Then you just get to say on everything you're pulled over, like, I didn't know my brake light wasn't working. I didn't know I didn't know what the speed limit was. I didn't see that change.
but
How would this be different than something else that we know of that's in the transportation code, like the speeding violation?
well, want to think about the reason for a second on why speeding may not require, you don't have to know, of course, the example the court gave was, you don't have to know the law, it's the facts. You never have to know your criminal, your activity is illegal. You have to be knowledge of the facts that you're doing that make it illegal, right? It's just like, you don't have to know that stealing is illegal, but you do have to know that you are taking someone else's property.
Right.
Which you thought it was your own property, that was.
So you're saying if you don't know you're speeding, then you can get out of your ticket if you don't know you're speeding?
Well, first of all, speedings are presumption offenses, so even then, just because you're speeding doesn't mean you're guilty. But,
I'm not going to add a couple of mental let's just stop here. And I am not, for purposes of this hearing, going to require or add some mental culpability that's not specifically listed here in Transportation Code 504945.
Okay.
So,
and for purposes of that, I just want to make an objection for the record.
sure.
Because I do believe that a proper mental state is required to be proven by the state. In this particular case, based on my interpretation of the Penal Code 6.02, it states that an offense does not prescribe a mental state. One is nevertheless required under subsection B. Intent, knowledge, or recklessness is enough to suffice. It does not state that criminal negligence is enough to suffice. That's what I stated earlier. I thought that the way.
So, I mean, I could say, okay, he was reckless by displaying it.
If the court made a finding that he was reckless in displaying the fictitious license plate.
I think absolutely he was reckless in that. I mean, he had owned the car for 2 to 3 months prior, still had paper tags on it. Anybody who, especially someone who's buying and selling vehicles, as he says he is, should have some idea of the requirements with regard to title. And you don't drive around with an out of date. Number one, you don't drive around with an out of date valid tag, and you definitely don't drive around with one that is not valid. So I am then going to make that finding that he displayed on a motor vehicle a license plate that was assigned for a registration period other than the registration period in effect, and in addition that it was fictitious, and find that he was reckless in doing that.
Okay, and Judge, I believe then what my objection will be as far as the mens rea being used by the court is that.
I used the one you wanted.
No, I understand that. Well, I'm kind of, right now, we're in argument, or are we? I want
Yeah.
to clarify what I thought the proper mens rea was for the court to decide. the
Okay.
issue. My argument would be, if we're in argument now,
Sure.
is that that if, in order to be reckless, he would have to have some knowledge of the falsity of the tag, not simply failure to vet it. There would have to be the nature of the degree constitutes a gross deviation from the standard of care that ordinary person would exercise under all the circumstances viewed by the actor's standpoint. But he's got to consciously disregard those risks. And I don't believe that receiving a paper plate and just simply not ever looking into whether it was valid or not would be consciously disregarding a substantial and unjustifiable risk. Now, it may not be best practice, but I don't think that that's a substantial and unjustifiable risk. If it was shown that he had knowledge of its falsity, not only intentionally, knowingly, but then he would, in fact, be consciously disregarding those risks because he's aware of those facts and he's ignoring them. But I don't believe the facts as shown today would show that he had any knowledge or that he was disregarding those risks. Now, as far as that offense, we are talking about allegation regarding, I guess that'd be number 2 for the fictitious license plate. It's a he said, she said as far as what he knew, Judge. But all I can say is that when the officer pulled him over, the first thing he said about the plate was, where'd you get the car? I got it on Facebook. He said that immediately. He said, who'd you get it from? He said, a Mexican guy. And he said, did the car come with a plate like that? And he said, yes. And he answered those very quickly. There was no hesitation. He wasn't trying to think about his answers. He gave those answers very quickly. And then he immediately handed the title to the vehicle where he purchased the vehicle to the officer. And it had Hispanic names on there. The officer did nothing to look into any of those prior owners. He didn't contact anyone. You know, it would have been helpful probably if the Hispanic guy that sold Mr. Green the car, if the officer got a hold of him and he came to court today under subpoena and testified that when he sold the car, it had the original plate. It did not have that fictitious plate. That would have shown you that it is not the way the vehicle came. But the officer, after making the arrest in this case, he didn't do anything to verify.
Neither did Mr. Green.
Sorry?
Neither did Mr. Green for, he said, about 3 months to get that car either titled correctly and the registration done correctly.
Yes.
So I understand your argument with regard to that. Go ahead if you have more, but
Just the argument would just simply be is based on his quick responses. I believe that his responses were true and accurate as far as that he understood them. And they're consistent with what he told the court today. And I think the title is consistent with what he told the officer. And I think that any unknown about what, if there's any unknowns regarding that transaction, then that should be held against the government because it's the government's burden. And the officer could have easily tried to follow up some way on that title. He didn't do anything to do that. So I believe that it's their burden and they.
how does that negate? How does that negate him displaying, him not getting the license as required by law within the correct amount of time?
Well,
That's not the
his offense.
state's.
But he's not charged with unregistered vehicle. He's charged with knowingly or he's.
Assigned for a registration period other than the registration period in effect is one of them, and fictitious is the other. I believe one or both could apply. So how is it the state's responsibility, maybe after the fact, but why isn't it his responsibility for the 3 months before when he's driving around in the car to not get the registration correct?
It is, and if his allegation was failure to register the vehicle, he would have no defense to that. But he did not know. The argument I'm making is that he did not know that that was a fictitious license plate. And I also don't believe that simply by never registering his vehicle, that then makes him guilty of the criminal offense of displaying a fictitious license plate, because I think it requires more knowledge than simply not vetting it at all. It would require some reason for him to believe that it could be in fact fictitious. And that's what my argument was, as far as I believe the state would have to prove some element to that. And I don't think that they do that in this particular case.
And that's A4.
That would be
A3, the registration period, there's really,
I believe, in my opinion, it's the same thing, because the period of time listed on that plate is the fictitious part. It's not a real part. And again, if he did not know that that was an improper part. Then
but it was
again,
out of date, so he would have at least known that there was a problem. It wasn't an accurate date to start off with.
it was no longer an accurate.
Correct.
It became expired while he had the vehicle.
Okay.
If he was charged, if that offense was failure to register your vehicle, then he'd be guilty. If he would.
What's the difference between displaying a motor vehicle that the registration period other than the registration period in effect?
Well, because it was showing a date that was expired. My understanding was it's not alleged, he changed the date to make it match the period for right now. It was, even the date on the tag itself was too late. It was even if it was true, it was out of date.
Okay, all right.
So again, it goes back to his knowledge of the facts that make it fictitious or make it out of date. And if he's not manipulating the date, then I don't believe that that's what makes that statute false. So that was all regarding allegation number 1. I also think, well, I just simply say that even if the court believes everything is taken as true and disregards Mr. Green's version of how he got the vehicle and all that, recklessness, it would still require some sort of knowledge of falsity or being out of date and being reckless with the display of that. And the reason why I pointed it being out of date, even as according at the time of the arrest, was that to be guilty of that, I believe that you would have to be knowledgeable that it's displaying the wrong date. And I don't think it was really displaying the wrong date, because it wasn't saying it was not expired anymore. Even the plate was saying it was expired. If
We don't know if it was the right or wrong date, because if it was fictitious, it was all made up,
if it was fictitious, it's all made up.
right?
Right.
So we can't argue that part of it is real and part of it's not, I guess.
And I think most of that, it sounds confusing because I'm saying it from the perspective of Mr. Green.
No, I get it.
I'll move on to number two. Number two was possession of,
It's actually number one. It was the
Correct.
opposite.
possession of money laundering, possession of the money that had been money laundered. In that particular case, what Mr. Green testified to is that he had the money in a plastic bottle. That's where he keeps his money at home. That's really not uncommon. Keep them in the big clear jugs. That he testified
So are we talking about putting cash
into
into the small,
no, this 5
the
gallon.
5 gallon that has a small,
That's a small
lid?
thing, yeah. You
how do we
tip it
get
over,
cash out of that?
Tip it over, pour it.
Cash?
You have to tip it over and pour it out, yeah.
Have you ever tried to do that?
Well, mine's split open. Had so much change in there.
Well, change is one thing. Cash is another.
Let me tell you.
How do we get cash
I'll
out?
tell you. So my cleaning lady,
How did Mr. Green get his cash out?
well, I didn't ask him that question on the stand, and I don't know the answer to that.
Okay.
My cleaning lady got it out with the little long slender part you attach to the vacuum cleaner, and you stick it in the hole, and it sucks everything out.
Mr. Green, you're still under oath. How'd you get yours out?
I cut it.
You cut what?
I cut the jug because you can't reach it. You can only get coins out. You can't get the dollar.
Okay, go ahead.
And so, yes, it would have been ideal at the time. The officer said, where can you account for every single dollar that you got here? But for a person who keeps the majority of their cash at home, some people don't have bank accounts. He had a bank account, but it was obvious from the records that he's not really storing his money in the bank account. He would routinely take the money out of the bank account, which is consistent with what he said he was doing with it. But if an officer put me on the spot right now to account for every dollar in my checking account, other than saying I'm a lawyer and I made money last month, it would take me time to come up with every source. So at the time, it's not unreasonable that Mr. Green did not remember that he sold air conditioner 2 years ago on Facebook Marketplace. Now, maybe it would have been ideal if he said, oh, you know what, there was one time I went and picked up some generators and I sold about 5 of those a year ago or something like that. But I believe at the time, Mr. Green is trying to give the answer to the officers to move on to the next phase of this. He was not under arrest at the scene when this was discussed. At the jail, obviously, he believes that he's probably going to jail. At the same time, answering an officer's questions may not always be advisable at the time. But he didn't have a specific single source for the money. And so if you look at the bank statements and you look at some of those transactions, the sales on Facebook Marketplace don't account for necessarily all $20,000. But that's the best he can do in retrospect, trying to determine where all of his money came from, is to just try to find any sources of income that he can. And so between Cash App transactions on his bank account, between some of the cash transactions that he sold things on Facebook, cars or personal items, over a 2-year period is really very small. $20,000 to have for an individual over a 2-year period is not a lot of money. In the grand scheme of things, a person who mows yards could probably accumulate $20,000 in a 2-year period. But there's really no direct evidence here that the money was in fact drug money, other than the way it was banded. That is it. The government is basically making the argument is that because 2 years ago, Mr. Green was a drug dealer, or we believe he's a drug dealer, and because the money was wrapped up in rubber bands, we now believe that it's drug money. And Mr. Green kept his money at home, and he didn't have a particular job at the time that he could say all that money came from. So it came from 2 years of his life savings. I mean, that was really the money he had, $20,000. That's his life savings. And so I just don't believe that the government has really proven that this particular money, this particular juncture was actually from the sale of drugs. And that prior drug dealing was alleged to occur, that he pled guilty with several.
Okay. Give me just a second.
Oh,
There is one, well, I guess if I don't really have a brief rebuttal time, if they didn't say anything, I was just gonna say that there's a right time and place for some of these things. But we can address that with the government's motion after the court rules. That'd probably be better time to address any issues like that.
All right, at this time, with regard to, we'll start with count 2, since we talked about it first, which is the allegation that Mr. Green committed the offense of wrong, fictitious, altered, or obstructed license plate. I believe that the evidence, and obviously as the fact finder, I can choose who to believe and what weight to give, credibility, and all of that. Based on all of the evidence that we have hashed out over and over, and I've already said, I am going to find that count true. I do believe that Mr. Green did have some knowledge with regard to the fact that that was a fictitious license plate. He has, according to his own testimony, if he wants me to believe that part of it, had part of what he does is buys and sells cars and would know what it takes when you have a car to get it registered, or have the license correct, or the, not the license, the title. And so based on the evidence and all of that, I am going to find that there was some knowledge and that he did commit that offense and find it true and beyond a preponderance of the evidence. With regard to count 1, I believe that the testimony, the videos, I've done a little bit of math up here. If Mr. Green saved every single bit of what he's saying he did, which I find hard to believe because people spend money, people have bills, people eat and do other things, that money, I don't believe that it was bundled in the way to take it to the bank. I don't think he was taking that money to the bank because the whole point of all of his testimony was that he didn't like to have money in the bank. So why would you be going to the bank with money wrapped in dopers increments in your car? So that story kind of got a whole lot of mixed up. To say that he doesn't like having money in the bank and that's why he had all the cash, but then he was going to take the money to the bank. So in addition to the history, the fact that he's on probation for a drug offense, and that offense had indications again of drug dealing. He, right before this offense, was arrested not long before the offense that he was on probation for in the Chambers County. That case is actually still pending. I did get confirmation that it's set for a hearing on our docket call April 8th. So it is pending, has been indicted. And the stories about the Facebook marketplace and making money. I don't know that I don't believe that he did some of that, but I don't think again that added up to anything other than money to live off of and probably buy drugs potentially. With that, also like I had something else before I made my finding. So based on all of that, all the testimony, the evidence that's been entered, I am going to also find count 1 true at this time. So now argument with regard to punishment.
Your Honor, I just ask that the court at this time take into account testimony from Special Agent Park, the testimony from Ms. Bradley with the probation department about the other violations, testing positive for possession, testing positive for THC at least on 2 occasions, and positive for cocaine on 1 case, Judge. We'd ask that you take that into account in fashioning the appropriate punishment. I'll remind the court that we're actually not asking that you revoke his probation. We're actually asking you to leave him on probation and assess safety as punishment. I know that there are some impediments to safety, at least at this juncture. Ms. Bradley can speak to those.
Well, with pending cases, there's a problem.
But I think I've got to work around if the court wants to hear, but I think we can get there.
I know you can do what you can with the cases here. I don't know if you've talked to Chambers County.
That's my plan, Judge.
Okay.
I think that I don't want you to hit myself, but that is the plan. I feel confident in my ability to get that resolved. In addition to asking that this defendant stay on probation, in addition to asking that be placed in safety, we're asking judge, and we provided authority attached to our motion that you use that money, which the defendant has claimed to be his money, to there's authority to say that the court can order that he reimburse the state for the cost of the safety. If you're not inclined to do that, there's also authority that says that you can assess, you can reassess a fine, particularly in the context of a deferred adjudication, not ask for the max fine on both of those cases of $10,000, and also in the alternative, or in conjunction with, I ask that you order that his fees associated with both probations be prepaid, again, coming from the proceeds of that, the money that the court has found true with regard to being proceeds of money laundering.
Mr. Gilmore?
What's in
No, I haven't heard it in years, but yes, sir.
the difficulty at this moment in time is that, number one, he's got a pending case. So the government's asking for an outcome that is a difficult outcome for the moment because he's got these other pending cases. And then he's got the pending case in Chambers County as well. And so I think maybe if the state and I discussed it for a second, then either we would come up with a plea agreement that would contain that, or not, because they can't go to, they're asking for him to go to rehab, they can't go to rehab with pending cases.
So here's what I have done and would consider doing in several cases is I have ordered it even with pending cases. And then either those cases are worked out, dismissed, or if after some reasonable amount of time. So if we are down the road and he's still in jail and they have not been taken care of for him to be able to go, and what I would think would be reasonable would be, about 90 days. If he's still sitting at 90 days, that's half of what he would be at safety. Then I have held that in abeyance, let people back out, JCDI, things like that are outpatient instead of inpatient. And so that's what I would be more inclined to do.
The concern is I don't know that he can get to Chambers County to resolve the case unless they dismiss it.
So we've done that. So we can finagle holds a little bit so that if Chambers County has a hold on him, we contact Chambers County. We release our safety hold for him and they'll come get him, take him to Chambers County. They take care of that case. And what happens is as soon as he gets to Chambers County that day, we put the hold back on so that when he completes that case, we've got the safety hold. So, I mean, it all, we can make that happen.
We do not anymore.
Okay.
We have to mark it.
Judge, you ready for?
Yeah.
Okay,
Yeah.
so what we would ask the court to do based on the court's finding is to sentence Mr. Green to a rehab facility as the state suggesting. We believe that the moral recombinance therapy, or whatever they call that particular MRT, would be the appropriate program here because besides some failed drug tests in 2024, it has really not been the issue. Believe the court drug tested. Did you take a drug test for the court a while back? Oh, wait, you're wearing a drug patch now still? I mean, he's wearing a drug patch.
He's not going home today.
No, that's not what we're asking.
Yeah, MRT is that's like a class.
Well, no, they have.
The moral recognition program, there's,
At ISF,
oh, you're talking about cognitive ISF.
because if there's not a drug issue, I mean, I think that the court, I would be reluctant to the court spending a lot of resources on a drug treatment program. If the court thinks drug testing today might be important, well, then go ahead. If he's got a drug problem, he's got a drug problem. If he doesn't, he doesn't. And that's all I'm saying is that.
So here's an idea would be, another thing that I meant to mention that also went into my finding was, and obviously I know that you're with regard to the facts and the suppression and the dog and the alerting. But for punishment purposes, the dog did alert to drugs on that money as well. And so I had that notation and I knew I had one more factor that went into my finding of that one true. I think that could also, though, lend to, I'm not opposed to cognitive ISF,
It appears based on.
with JCDI.
Many months of wearing a drug patch without positive results.
Ms. Chapa Bradley, thoughts on ISF cognitive with JCDI as aftercare?
Yes, ma'am.
Yeah,
I believe that the cognitive therapy would probably suffice for what he needs.
What's going on.
90-day program as opposed to the 6-month.
right,
It is something that I think we consider.
okay.
If I may, Judge, I think the same authority that we have that applies to having the defendant reimburse the
Sure.
state for safety applies to reimburse the state the cost of the cognitive ISF.
It does, I mean, the documentation that you attach to your motion specifically has ISF listed as, I think it's the same cost. I think it's at 82.
But I think, I don't want to misrepresent anything, it's attached. Motion.
It says while ISFs are not listed as a separate category, their costs are reflected within the broader system-wide cost per day, which accounts for all facility types. And so I think that amount of 80, the system-wide cost per day, this is from 2024 fiscal year, was 86.50. And so I would definitely be inclined to require that be paid and reimbursed out of the proceeds from the money that was taken that day.
And I've listed the process in my motion, because I know this will be something unusual.
It will be.
For the clerk's office and all the parties involved, but the
You'll
process
just have to
is there.
help with that. So, okay, so here's what I'm going to do then. Again, made the findings that counts 1 and 2 are true. Find sufficient evidence in cause number 23 DCCR 1502 to find you guilty and revoke your probation. However, I'm not going to do that. What I'm going to do, Mr. Green, is continue you on probation and order as a condition of your probation in each case. 24 DCCR 1320 also make those same findings of true to counts 1 and 2. And order as a condition in each of those cases that you enter and successfully complete the ISF program cognitive track, and that upon release, you will enter and successfully complete the JCDI program. That will address the possibility of any issues that will help you make better decisions with the cognitive track, and so you can be successful on probation. It will also then address any potential drug issues that are underlying as well. And so Mr. Coleman will help. I'm going to order in each of those cases that the proceeds, the proceeds that from that arrest will be used to reimburse the state for the cost of the ISF program. And then we will, if you guys want to, Mr. Galmore and Mr. Coleman, if y'all want to get with Chambers County and get a plan, if we need to release that ISF hold with their hold and get him over there, we can get that taken care of. If there's just whatever y'all want to do with these cases, the new case here, we need to get all that taken care of. Again, if it's not within, I'd say, again, for sure in this case, a reasonable amount, which would be about 90 days. Then just get back with me, and then potentially we'll figure out what to do at that point to hold it in abeyance if necessary.
Yes, Judge, just a couple of other housekeeping matters. I don't know if the court's inclined to revisit the state's request that possibly the fine or fines in this case be reformed.
I'm not inclined to change the fine. I don't disagree with your reading of that. I don't know the legality of changing a fine after the fact.
No problem, Judge.
So I think
Understood. What about the fee, prepayment of the, or at least payment of all of the probation fees?
he's up to date on his fees. So he's been using some of his money at least for that, which is good. And so since he's up to date on his fees, I'm not going to require that. Obviously, if there's money and we know there's money coming in from different things, don't come back later behind on your fees and say, well, you know, I don't have a job. So if you need to get a job that has income, do that. If you're gonna keep doing what you're doing, I think you need to be careful with what you're doing. Buying generators out of a storage unit seems awfully sketchy to me. I would have a hard time believing that those were not potentially stolen. I'm not saying you stole them, but I'm saying you better be careful with how you're making your money and not just assume that things aren't stolen. When you're getting a really great deal on something, it's probably because there's something wrong, right? So I think that's kind of my position on that one. All right, anything else?
The reimbursement to the state, is that a condition of his probation or just something?
It's a condition. I'm gonna make it a condition of his probation. I think that'll make it where it's an order. I think I also can sign, I have an order. I don't know if you filed an order with it. I can adjust that order.
There is a proposal. After I've got check boxes, you can just check.
You do, and it's the first one, correct?
Yes.
Even though I'm gonna change that substance abuse, and then no less than 240 days. And put ISF instead. Intermediate sanction facility.
It has a dollar amount per day of $85. I don't know if you want to change it to the 86 or. It's up to them, whatever the court wants to do.
I'm gonna leave it at the 85. Or less than,
Oh, it also says for a period of 240
I'm
days.
changing that to 90. Okay. And then I'm gonna mark through just to make sure that the others, I'm not holding. All right, anything else?
Not from the state judge. Sure.